are now live. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. Welcome to the Appeals Court. I'm Judge Milkey. With me is Judge Desmond and Judge Englander, and we are your panel on all 6 cases today. Our first case is Commonwealth versus BOBILIN, 2020 P536. I would remind counsel that we are going by the same rules as ordinarily applied to our live hearings. And in terms of 15 minutes per side, no time for rebuttal. And I would simply remind counsel that we have read the briefs and are familiar with both the facts and the arguments. So I would urge you both to cut to the chase to the extent possible. And with that, I will turn the floor over to Mr. Smith.
Thank you, and good morning. May it please the court, my name is Andrew Smith and I represent Mr. BOBILIN. Today I'm here to ask this court to overturn Mr. BOBILIN's conviction and to return his case to Franklin Superior Court. We ask for you to do this because the trial court made 3 separate errors. First, it allowed the Commonwealth to elicit testimony on an ultimate issue in the case from the police officer who pulled over Mr. BOBILIN. Second, the court erred when it allowed, again over objection, to the administration of the HGN test. And finally, third, that the officer who arrested Mr. BOBILIN knew Mr. BOBILIN not merely by sight walking around town, but from calls that at least suggested inculpatory interactions with the police.
Counsel, turning to your first point,
Sure.
It's well established that an officer can testify to his opinion that someone is intoxicated. How is the jury going to hear that any differently from what this officer did testify to, namely that in his view, the defendant was under the influence of alcohol?
Well, I think I think in Canty, the court was drawing a line between you can describe what he did, you can discuss whether you thought he was inebriated, but in this case, the officer uses the exact language of the jury instructions, which is the issue from Canty.
Well, but he doesn't say that he's I'm sorry. Go ahead, Ken.
Well, I was just going to ask, I mean, the defendant is arrested. I mean, doesn't the jury just by common sense form the opinion that the officer must have thought he was impaired because he arrested him? Why else would he have been arrested?
Well, if that's the case, where our jury instructions aren't working, that's the jury's job to figure out.
I understand it's the jury's job to figure out beyond a reasonable doubt. I'm questioning is, what is the jury left to infer by the defendant's arrest? Simply by his arrest.
That well, there are 2 separate questions. The jury can infer that the officer observed the defendant acting and behaving in a way and moving in a way that suggested some level of intoxication. The issue here is he goes beyond that and literally uses the language of the jury instruction. Says,
but he doesn't. What I started to ask before is he does not use the language of the jury instruction, or at least he doesn't use the language of the offense, because he doesn't use the word operating under the influence. He simply says that he was under the influence.
But they stipulate that they were operating. That seems
well,
like
but that's not the officer's The officer didn't stipulate to that. The officer, I mean, the difficulty that we have, it goes back to, I think, Judge Milkey's question, which is, Canty draws a line. It says that the officer can give the opinion that the person is intoxicated. The officer cannot give an opinion on the ultimate issue, which is that he was operating under the influence of intoxicating liquor, right?
Yes, but if we just look at the elements, those are two separate elements.
Operation and being under the influence, right?
So
Right. And without giving an opinion as to both, you're not giving an opinion on the ultimate issue.
well, he certainly gives an opinion. I mean, he speaks to him operating, and it was stipulated by the parties.
I understand.
Counsel, didn't the judge here expressly instruct the jury as soon as the officer had testified to this, that it was their job, not any witnesses, to determine whether, as a matter of fact, your client was operating under the influence?
And that's absolutely true and fair.
So how is this any different than Canty, in the sense that, in Canty, they found error, they found preserved error, and yet they affirmed the conviction, given that the concern that the jury would unduly defer to the officer in combination with the strength of the evidence was enough to satisfy the court that there was not reversible error.
Well, my response to that would be, this jury deliberated for days on the issue of guilt. So here we have a case where we have three errors. One appears to be spot on with Canty, and we have a jury that clearly was tangling with a complicated set of facts and was uncertain of guilt. And perhaps this error is not sufficient in itself, but it certainly, in combination with the other two, makes for at least some doubt about the jury verdict.
Do you want to, unless my colleagues have further questions on the Canty issue, do you want to turn to your other?
Yes, that's, unless there are other questions.
Seeing none, why don't you turn?
Thank you. In our second issue, and I must admit, I worked in the district courts for years. I had never seen this end run before. I understand it comes out of an unpublished case, but the court allows the Commonwealth to elicit testimony from the officer about the HGN test, which is clearly not allowed as far as the HGN test.
Can I stop you there?
Certainly.
The testimony I read was not elicited about the HGN test, quote unquote. The words HGN or NGT or whatever the right initials are never uttered. There's no description of it as being a special test. All that is described is that the officer gave some instructions to follow his finger, right?
And would not a juror, and the testimony then follows, he couldn't follow my finger.
He couldn't follow the instructions. The issue was not about the nystagmus gaze. It wasn't about his pupils being dilated. It wasn't about any of the science. It was whether or not he could hold his head still until I told him to, follow the finger one way or the other. It had nothing to do with the science.
And that's true, but to a juror, isn't there a danger that just from common sense and experience in the world, they would think he couldn't follow the finger, therefore he failed the test? I mean, I think that's the danger here.
Well, but let's assume that that is a danger exactly as you just described it, that the jurors might think that he couldn't follow the finger and therefore he failed a test. How is that prejudicial? The officer, what the jurors heard is the officer asked somebody follow my finger in the following way, and he couldn't do it. How is that an indication that improper science was being brought to bear?
I'm not saying improper science was being brought to bear.
I think you are. I think that that's the entire basis for this argument, is that improper science was being brought to bear, because if all we have in front of us is observations from an officer and common sense, then I think it's probably okay.
But the testimony is he moved his head and couldn't follow with his eyes. That's not science, but that's also not, that seems to me to be different than he's not following instructions. That seems to be an issue of he's out of it.
Well, but okay. And the reason you say that is because that's common sense to you, that comes from living a lifetime of knowing whether people can follow your finger with their eyes. And it seems to me that's within the knowledge of a jury, and not improperly presenting them with science.
Well, that may be true, but then it's almost like we're on the verge of going back to allowing him to testify to the HGN.
No.
Right, because he's basically saying he failed the test. So why wouldn't we have the officer just testify to the science? I mean, I understand, but at the end of the day, the testimony from the officer is he failed the test.
So, well, but the officer didn't say he failed the test. He said he couldn't follow my finger with his eyes, or he couldn't hold his head still and follow the directions that I gave him. I mean, they do the same thing with FSTs, right? That's exactly what they do. Part of the FSTs are, could he stand on one leg? And part of it is, could he hold his foot parallel to the ground? And could he not start until I told him to start? And that part has come in historically as being evidence that a jury can understand as common sense that a person who's under the influence of alcohol may not be able to follow directions.
Well, and that's the Commonwealth's argument, is his inability, well, in effect, the argument is his inability to follow the finger is divided attention. I don't see it as divided attention. The testimony, it's not he's trying to do two different things, or he's being distracted by one thing and missing the other. He can't follow the finger moving.
To begin with.
That's not divided attention, I don't think.
Unless
I mean,
the jury
they bring it in
infers
under
from that he couldn't follow the directions as to how he was supposed to follow the finger, which was to keep his head still and have his eyes follow the finger.
Well, perhaps the implication then is he couldn't follow the instructions. I mean, I think that's probably it's not that he can't follow. It's not that he didn't understand, he just couldn't follow. And that's getting very close to the HGN test.
I see your time's running out. Can I ask you why you think that did we lose attorneys? Why you think that the fact that he recognized him from calls had some type of nefarious or negative connotation? Maybe they were calls as a good Samaritan.
Because we don't know.
So why do you attach a negative connotation to it?
And it would be a fair speculation. It may not be
speculation, right? It would indeed be called for speculation.
Oh, of course.
Okay.
But wasn't the most specific reference in the testimony that the officer would see him walking along the officer's patrol route?
I have no problem with that. That's not the piece of testimony we're just.
No, I understand that, but that was, having read the transcript, I think that was the most specific reference in terms of how the officer was familiar with your clients. So I'm having a hard time seeing much danger here.
But the richest reference was, and again, the Commonwealth is representing the testimony, is making a proffer about the testimony before it's made, that it's about him walking around town. And then during the testimony, the officer comes along and says, and I've interacted with him on calls. And the issue that comes out here, and I see him getting close, the case of pleas is the calls are suggestive. The issue is really, well, there's certainly the danger of calls, but there's also an issue of if it's inculpatory, the Commonwealth, the defendant cannot cross-examine the witness because in the course of cross-examination, they bring this out. I see I'm out of time.
Thank you, counsel, unless my colleagues have any further questions. Seeing none, we'll hear from the Commonwealth.
Thank you and have a nice day.
Thank you very much. Good morning, Your Honors. Stephen Gagney. I'm the first assistant district attorney for the Northwestern District. I was also the trial prosecutor in this case. With respect to the first issue, the so-called Canty issue, I think the SJC has drawn a very clear line and the Commonwealth complied with that line. This was a matter that was discussed at sidebar pursuant to an...
Counsel, if I can just stop you here, there was no question that the defendant was operating his vehicle directly before the officer stopped him and made the observations he did. At least under those circumstances, why wouldn't the jury hear a statement that he was under the influence as equivalent to he was operating under the influence, which under Canty crosses the boundary?
Well, those are two separate elements, I admit, but as the trial judge instructed the jury, what they're really were being asked to decide was whether or not, as a result of Mr. Bobilin's consumption of alcohol, he consumed enough where it reduced his ability to drive safely, reduced his mental clarity and self-control. And this is at volume 2, pages 202 and 203 of the judge's final charge. So it's not just a matter of, the jury wasn't being asked to decide basically just was he or wasn't he under the influence. It wasn't a one element case. It was the intersection of his impairment with his ability to operate a motor vehicle safely. So I would suggest that even though the defense may have stipulated to operation or that operation was essentially not contested, it was still more than just whether or not Mr. Bobilin was under the influence generally. It had to link specifically to his operation. And that's where the officer was careful to hew to the Canty guidance of not saying he was operating under the influence. That was the mistake or the error that was made in the Saulnier case, which my brother cites, where the officer went too far and not only saying that he was, the defendant was impaired, but that his ability to operate a motor vehicle safely was impaired. So there was no such error in this case at all.
Do we have any other, are any of the other cases where the question was actually asked using the words under the influence, as opposed to did you form an opinion as to whether or not, or did you form an opinion as to his state of mind, or did you form an opinion as to whether it was intoxicated? Here, your question was use the words under the influence.
Mm-hmm. I have to admit, Your Honor, I didn't survey the cases to see what terminology has been used in various cases, including Canty, but I would suggest that whether or not I don't think Canty comes down to really a matter of which specific words or semantics, whether it's intoxicated, whether it's impaired, whether it's under the influence, it's all essentially conveying the same thing.
Okay, but if it doesn't make a difference, why not stay away from the statutory language?
If there were guidance, a clear guidance from either this court or the SJC that would say essentially it's best to perhaps not identically track the jury instructions, then I think moving forward that may be a fair rule. It may be a safer rule, but Canty hasn't set that guidance. And I think it's still, when the judge comes in right after that answer from Officer Biseglia and gives that clear cautionary limiting instruction to the jury, he's hammering home to them that just because an officer may use words that track the jury instructions, that does not invade their province. It's still their call as to whether or not they think Mr. Bobilin was operating under the influence.
To the extent that his driving was impaired, simply as you've stated, operating under the influence, I'm not sure, is that enough? Are you conceding that that's enough, or does the operation under the influence have to impair his ability to drive safely? Can't somebody be operating under the slightly intoxicated, but their driving not be impaired?
Well, it's true that one's operation need not specifically be dangerous or unsafe, and the judge instructed on that. I suppose in theory you could have a person well over the legal limit who's driving perfectly safely and not even speeding, but that person would still technically be operating under the influence, because the theory being if there's a sudden unexpected event, a child or an animal darts out, one's reflexes and mental clarity, their focus, those are things that a person really doesn't have as much control over as to whether or not they're using a turn signal or staying within the lanes. So it's still, as I said, the intersection of impairment of one's ability to drive safely and based on intoxication. If there are no other questions on that topic, I'd just like to briefly touch upon the HGN issue, or the follow the finger test, rather. It's been suggested that somehow the Commonwealth did an end run, or this was backdoor. If this was an end run, it was very poorly executed, because I specifically suggested to the judge that this is exactly the line that I'm suggesting we draw, that we stay away from science, we stay away from any mention of involuntary jerking or 45 degrees of nystagmus. The judge specifically heard argument on this issue, made a ruling, Commonwealth complied with the ruling. There was no objection from trial counsel in the manner in which we complied with that ruling, and it listed the testimony from the officer. And I think the testimony—
Is it your contention there was no objection as to the evidence that came in?
There was a motion in limine regarding HGN,
Right.
and the judge ruled on that, saying science is out, but lay observations of how we followed the instructions or lack thereof is in. And when that testimony came in at volume 2 on pages 71 to 73, there wasn't a peep out of trial counsel. There was no objection.
But you think it's not covered by the motion in limine?
I do. I think that the motion in limine was specifically geared toward the science of the HGN test, and that portion of the motion was essentially allowed without objection. The Commonwealth never even fought that issue. We did not suggest. We were well aware of the Sands case, the requirement for expert testimony. If you're getting into the science of HGN and why the eye reacts a certain way.
I'm reading the bottom of page 212 of the transcript of the motion in limine. And it says, so I object, I'd like it all out. That's the end of the statement by defense counsel. I have trouble believing that this issue is not preserved, given that statement, which the judge overruled and allowed you to put in what you put in.
Oh, Your Honor, I'm sorry. I didn't mean to suggest, perhaps I misinterpreted your question. I'm not saying that this wasn't preserved. I think he filed the motion.
I think you did misunderstand my question, because that's what I was trying to get at. Okay. Then you begin your argument by commenting that this isn't an end run because you were upfront about what you were doing. But I think the question really is whether it's an end run on the case law, which says that you can't put this test in without some sort of expert testimony. And as to that, isn't there some merit to the notion that you are asking questions that are going to leave the jury believing that you administered some kind of test as to which the defendant failed the test.
I would say this is hardly different at all from any other test where you're asking someone to follow fairly simple instructions. Don't turn your head, follow, and he's literally 5 times he's can't follow that simple instruction. So that's as simple as don't raise your arms during the 1 foot stand. Walk following this line in the road. Don't wander off. I think the impression to the jury was simply that just like any other request to follow an instruction and perform a relatively simple task.
Counsel, did well, you were the prosecutor.
Yes.
Did you ever argue in the closing or otherwise that he failed the follow the finger test?
I think from what I can recall, in the closing argument, I did refer to the fact that he wasn't able to follow the officer's instructions and he didn't perform well on these roadside tests that the officer had him do, but I never delved into involuntary eye movements or the 45-degree, the onset prior to. All of the science of HGN was never brought up, never went near that.
No, I was specifically referring to the line between passing and failing. Was it ever characterized in those terms?
I don't believe that, no, I don't, first of all, no. I'm just doing
Well, you use the term test. That's your term. And then it's adopted by police officer. When you instructed Mr. Bobilin on how to perform the test.
The officer did not, yes, the officer did not testify that Mr. Bobilin failed any particular test. I had him go through each test and describe Mr. Bobilin's performance. I didn't say, in your opinion, did he pass or fail any particular test? Once I had gone through all of the field sobriety tests with Officer Biseglia, I asked the officer, the wrap-up question was, sir, based upon Mr. Bobilin's performance on all of those tests and your observations of his, walking, his speaking, the odor of alcohol, did you form an opinion? So the officer properly avoided any opinion as to failing or passing. In closing argument, I think it's fair game for a prosecutor such as myself to say that Mr. Bobilin did not pass these tests. He failed them. He failed pretty miserably. He couldn't get from A to Z. He got stuck on the letter T and then just started rambling. I think it's fair argument, and I think jurors would understand that if you can't say the alphabet, you failed that test. I think that's within the bounds of fair argument. But I didn't have the officer cross that line, and we certainly never went into science. Now, if I just, in the time that I have remaining, lastly, the officer being familiar with Mr. Bobilin, this had relevance. It's often the argument in OUI cases such as this that an officer has no baseline, an officer doesn't know how a person usually walks or usually talks. Well, that wasn't the case here. From being a patrol officer in a small town, Officer Biseglia knew Mr. Bobilin, had seen him walking along the route to and from work.
Your brother quarrels with the call portion of that examination. What do you say about that?
I see nothing incriminatory about that. I think calls is a very innocuous term. It could have been fender benders, could have been medical events, neighbor disputes, could have been Mr. Bobilin calling the police on suspicious activity in the neighborhood. Police engage in all sorts of calls, not just responding to crime. But I think the real problem with defense's argument on this point is that the record is completely devoid of any support that there were actually crime-related calls that Officer Biseglia had responded to, or that Mr. Bobilin had any sort of criminal interaction with Officer Biseglia. There was no voir dire on that. There's no record evidence. Trial counsel never complained that his ability to cross-examine the officer was being hindered by that. Unlike one of the cases cited by my brother where there was a parole officer testifying. Now, those are treacherous waters. If you're trying to cross-examine a parole officer, you can only go in the water so deep before you're going to get bitten. But here, it was there was never any suggestion that trial counsel was handcuffed in his ability to cross-examine the officer. And this is actually a very experienced trial counsel too. He's actually the head of the public defender's office here in Northampton. He's a 30-year trial attorney. He very well would have known that he could have called for a voir dire on this. He could have had the trial judge instruct Officer Biseglia not to mention any prior negative interactions with Mr. Bobilin. So all the jury was left with was that this officer had spoken to Mr. Bobilin before, seen him walking along the road, and had interacted with him during some calls.
Now, counsel, on the preservation issue, on this issue, there was no written motion in limine, but counsel did raise his concerns prior to the trial, making it at least similar to an oral motion in limine. Why isn't that enough to preserve the issue on appeal?
Well, I don't think trial counsel saying that he was a little bit worried about this issue is enough to really preserve it. Even if it were preserved, though, even assuming arguendo that this was a full-blown objection and that it was preserved, and if he had objected at the time this evidence came in, which he didn't, still we're left with the fact there's no error here. It was completely proper testimony. So we don't even need to get to the analysis of whether this was prejudicial or whether it was a substantial risk of miscarriage of justice. Unless your honors have any further questions, I see I've got 8 seconds left. I would simply ask you to affirm Mr. Bobilin's conviction.
Seeing no questions, thank you both very much. The case is now submitted.
Well argued. Thanks, folks.
Thank you.
All right, we are live and recording.
Thank you very much. We are here for the second case of the morning, 2020 P 944, Commonwealth versus a juvenile. I would remind the parties that the case is impounded, so please, no reference to names. And the only other thing I will mention before turning the floor over to Mr. Toomey is that I want to assure you that we have read the briefs and record, so we are familiar both with the facts and the arguments. So we would urge you to the extent possible to cut to the chase. Mr. Toomey.
Good morning. May it please the court, Dennis Toomey on behalf of the juvenile. We're asking you to please reverse the order which denied the juvenile's motion to suppress. Imagine that this was one of your own kids waiting for a haircut at your local barbershop on Main Street in your own hometown. That's what it was like for this juvenile when 4 armed police officers barged into the barbershop, seized the juvenile, put their hands on him, grabbed him up out of his chair, and then pat-frisked him in broad daylight without even doing a threshold inquiry. And when we consider how the informant's tip lacked any unique descriptions and the passage of time, and how the police observations when they arrived on the scene did not match what the informant had seen or what the informant had reported, because the informant said nothing about a black male being alone in a barbershop, it's clear that the warrantless police actions in this case were unreasonable. Regarding the passage of time, one of my mentors, Jim McCall, always says,
the police were responding to a confidential tip, right? And one that had considerable weight behind it. Do you disagree with that?
We have not conceded the informant's reliability or veracity.
Well, but they don't have to meet the requirement of the Aguilar-Spinelli test in order to do a stop, right? I mean, our law literally says that it's a relaxed sort of standard of reliability and veracity.
Well, my argument is that even if the informant was completely reliable, that the police still lacked reasonable suspicion to stop and seize this juvenile, because what the police saw did not match what the informant claimed to have seen, which was 2 men on the street, not one juvenile in a barbershop waiting for a haircut. And when you combine that with the passage of time, I think that it's clear that a black male with a hoodie. What is the
passage of time that is reasonably inferable from the evidence that was before the suppression?
Based on the evidence, the passage of time was anywhere from 30 minutes to 3 hours. from when the informant made the observations and when the
Well, but
police.
one of the witnesses, and he credited all the witnesses, one of the witnesses said that he made the call at 5 o'clock. It was the witness who received the confidential tip. And the actual stop, seizure, occurred at around 5:30, right?
That's correct, Your Honor.
All right, so
So we
let's
have-
deal with, go ahead. So let's deal with that as the premise. I mean, the 2:30 business, trying to keep the informant's identity confidential, I get it. But to Judge Englander's point, let's say 5 o'clock is the call, 5:30. You think 30 minutes is an exceptionally long period of time?
I do, given the transient nature of the tip, which was that two men were walking on the street corner. And then given the fact that within those 30 minutes, a black male wearing a black hoodie, having a gun, could have easily left the area. And then a black male in a black hoodie without a gun could have arrived for a haircut.
And
that's a
counsel, I take your point, and I think that point's valid. We're talking about reasonable suspicion. The police have tip from a confidential informant who the evidence that was put in, although apparently struck, was 24 times he'd given them good information. So let's just take it as an assumption for now that the police believe that there is a young black male in a black hoodie and jeans on that block at that time with a gun. They don't have the authority to stop someone who matches the clothes?
No. My answer to that is no, Your Honor. Black hoodie and black male, that's simply not enough under the case law. Commonwealth versus Warren, which was decided the year after this case, because this is an older 2015 stop, makes it very, very clear that there's no reasonable suspicion to stop a defendant when the tip lacks detailed information about the suspect that would allow police to distinguish this defendant from any other black male wearing a hoodie in the city. That's Warren to a T. And I think the proof we have here is that the police actually pat frisked 3 black males when they responded, which I believe is the heart of this case. The young
So they
black male.
pat frisked one who matched a description of the person who was with the person with the gun. And then they pat frisked one other person who had jeans and a somewhat black hoodie. Is that the evidence that went in?
That's correct, Your Honor. And
was there evidence of where the second person who was pat frisked, is there evidence
Yes.
of where that person was located in relation to the person with the white or off-white hoodie?
yes, the black male in the black hoodie named Hollis, who was outside on the street near the other black male in the off-white hoodie, Norwood. The record doesn't make it clear how close they were standing together, but they were both outside together. Police pat frisked Hollis, the black male in a black hoodie that had some gray on the sleeves. And that raises 2 questions that I think go to the heart of this unreasonableness. If Hollis did not match the description because he had a little bit of gray on his black hoodie, then why did police pat frisk him?
Right. Did the police ever see 2 people, one with a white hoodie and one with a black hoodie together?
Only when Hollis walked away with Norwood, Your Honor.
Okay. In Hollis, he was the one with the black and gray hoodie?
That's correct, Your Honor.
And wasn't solely a black hoodie, but he got pat frisked anyhow, right?
That's correct, Your Honor.
The guy with the white hoodie, there was no report that he had a gun. He got pat frisked anyhow, right?
That's correct, Your Honor.
Does Hollis look like a juvenile? Was Hollis a juvenile?
His age was not clear from the record, Your Honor.
What do we know from the record in terms of how close the person in the white hoodie or off-white hoodie and the person in the black and gray hoodie were to the barbershop?
The testimony varied. The clearest description was 100 yards away, but they were standing within the same city block. I attached a map in my addendum that shows where the barbershop is in between those 2 streets on Columbia Ave. So roughly 100 yards away, perhaps, standing on one of the corners. But that's a very busy public area. You'll notice from the map that there's a convenience store, a church, barbershop there. So this is like any other main street in any other city or town in Massachusetts. And the case law is clear that mere proximity to...
When you say that, where can we find that in the record? I unfortunately, some of the folks on this panel are probably quite familiar with that area. I am less familiar with that area. Does the record describe it as a busy Main Street?
Yes, it does. Trial counsel did elicit that there were many businesses and schools on that area. And then again, in my addendum, I did attach a map, which is addendum 75 to my to my brief as well. So although they tried to characterize this as a high crime neighborhood or a gang neighborhood as well, it was clear that this street had schools, barbershops, and many businesses. And this is 5:30 p.m. in broad daylight. So,
But there's no dispute Columbia Road has a lot of crime. No dispute. Are you contesting that?
no, Your Honor, I'm not. I'm simply saying that the motion judge gave too much weight to this high crime area, particularly where there was no evidence that this was a high crime barbershop or a gang barbershop.
Gotcha. 270 Columbia Road's not on the opposite side of the street. Is that right?
Correct, Your Honor. It's up the road 2 blocks and it's a school.
And
I'm not finding your addendum. I'm sorry. I'm sorry, Judge Desmond. Sorry.
that's all right. Go ahead. I want you to find the reference. Where is it in the addendum?
It's page 75 of my principal brief, Your Honor.
Yeah, for some reason in the version we have, the addendum is not attached, at least the one I'm calling up. Okay, we'll figure it out.
The judge said that I'm going to move away a little bit from the description of the men to the stop in the barbershop. And the judge said that the observation of the bulge somehow led to or supported the reasonable suspicion. But didn't that come after he was seized?
It did, Your Honor. That's one of the most clear, glaring errors that this busy juvenile court judge made. It's clear from the testimony, it's undisputed that the police did not see the bulge until after they had grabbed the juvenile out of the chair with their hands and seized him. So the motion judge clearly erred by justifying that seizure based on the bulge they saw afterwards. That is a clear reversible error.
Well, wait, but all they need to do a stop, and in this case, I would think perhaps a pat frisk, is reasonable suspicion, right?
Yes.
So although a seizure occurred, reasonable suspicion to get him out of his chair would be sufficient to perform the limited seizure necessary for a pat frisk.
I agree that the police needed reasonable suspicion to stop and seize the defendant out of his chair. But that requires specific articulable facts that this juvenile had a gun, and that was missing. Just the fact that he had a black hoodie on and was in that general city block is not enough. It cannot be enough if Article 14 and the Fourth Amendment are to have any teeth. And the most important thing, I think, is when the police enter the barbershop, the juvenile acts appropriately. He does not blade his stance. He does not grab his waist. He does not turn away or flee. So all of those factors that the majority of this court found in the Karen K recent decision where Justice Milkey dissented, none of those movements by the juvenile are present here. So there's nothing that the juvenile did to suggest he had a gun. No plus factor that gets them over the general black hoodie description.
Well, I mean, so isn't that what it really comes down to, is what can the police do when they have a credible confidential informant who says on this city block at this time, someone is carrying a gun with this general description?
My answer is they could not do what they did here. They needed more. Perhaps if the juvenile had been seen walking down the street,
and he had white tennis shoes, and this guy had white tennis shoes, would that be enough? I mean,
I
it
would argue
really
that's
comes down to the genericness of, you say it's a generic description, right?
It is. If something was unique about the clothing that would distinguish him, perhaps, white shoes with a purple dragon logo, anything unique at all, a tattoo, a specific backpack, anything to separate this young man from all the other black males wearing black hoodies in that neighborhood.
Well,
That's all we have here. We have jeans and a black hoodie. Right?
That's correct, Your Honor.
We would have had
know
more had he been standing with the guy with an off-white hoodie, but he wasn't.
Correct, Your Honor.
and I guess we don't have any evidence about how many people were on the streets at the time or how many of them had black hoodies and jeans. What we do know, though, is that one other one was close enough that they decided they ought to pat frisk him.
That's correct. And I think that shows that this was an unreasonable generic search.
In fact, this juvenile, he wasn't on the street, was he?
No, he was getting a haircut or waiting for a haircut inside a barber shop that was not mentioned by the informant.
But it's not a generic search. It's not a generic search. I mean, it's not a search of everybody. They're not searching everybody who's on that street. They're searching people who match a description that identifies them by the pants they're wearing, the top they're wearing, their race. Is that it? Those are the only three things we know?
Yes, and I would suggest the case law is very clear. Those factors are not enough. Police need more to seize young men in the city. It's not enough. And again, this case took place in 2015 before Commonwealth versus Warren was decided and before the recent Evelyn and Long cases on race and bias and police stops. But this court should reverse to remind the police that they need more, that they cannot do this unless they have more specific information. Otherwise, their actions are unreasonable. And so, when the court considers the numerous glaring errors that this motion judge made, factual errors, and the errors applying the law to the facts.
The error that you're actually putting your finger on is that whoever took the information from the confidential informant didn't get a sufficient enough description.
Or that the informant did not see enough of a specific description.
Well, he saw a gun in somebody's waistband walking around the street at 5:30 in the afternoon. That's an issue, isn't it? That's something that the police ought to be paying attention to.
Well, perhaps based on the fact that the juvenile was
police,
young, but
when the police get a report from somebody who's credible, there's someone walking around at 5:30 this afternoon on a busy street with a gun. They need to try to do something about that, don't they?
it's not illegal to possess a gun unless you're underage. The tip did not say that this was an underage juvenile. There was the word young used, but no, police do not have the authority nor should they be charging into a barbershop without a warrant just because someone was possessing perhaps a firearm that could have been lawfully possessed or not. There was no threat of violence. They were not responding to an emergency. Informant claimed.
There was one other factor, which was that the gun was supposed to have been on the right side of his waist, right?
That's correct, Your Honor. But again, those observations were not made until after the seizure, so they're not relevant and they do not justify the seizure itself.
Do either of my colleagues have any further questions?
No.
Seeing I'm out of time, I'll rest on my brief.
Thank you very much, counsel. We will hear from the Commonwealth.
Thank you.
Thank you. Julianne Campbell on behalf of the Commonwealth. I'm here asking that this court affirm the lower court, the defendant's conviction in the lower court's denial of his motion to suppress.
Let me ask you this, Ms. Campbell. If the description was so particularized, why did they stop 2 or 3 other people before they got to the juvenile?
So I will answer that directly, and then I'd like to sort of address it in the larger context of what's going on. My first response to that question, Your Honor, I certainly do not condone the violation of an individual's rights. And if that individual, and I believe his name is Hollis, but in the black and gray sweatshirt, if his rights were violated, I would suggest that that would be problematic. But what I would point to this court's attention to is the fact that neither that individual nor Mr. Norwood's constitutional rights were at issue in the suppression hearing here.
I understand. My question's different. My question is, if the description was so particularized, why did they pat for 2 other people before they got to the juvenile?
And my response to that, Your Honor, is that not all of the factors that may have been relevant to the decision to pat frisk those 2 people necessarily would have been elicited at this suppression hearing because their rights were not at issue in this suppression hearing.
But counsel, what if they had found a gun on Hollis? I suspect the Commonwealth would be saying, well, I guess the CI thought the hood was all black. And
Your Honor, I would not argue that to this court. I would not. What I am saying to this court is, first, I would suggest that even if worst case scenario, there was, and again, I'd suggest that this is not adequately raised below at the motion hearing. Even if those two individuals, Mr. Norwood, who I think there's actually a compelling argument to pat frisk, but again, I don't think the record below was sufficiently fleshed out. But even if both of those individuals' rights were violated, I would suggest it does not detract from the reasonable suspicion as to the juvenile here. And I understand Justice Desmond's concern and the point raised by my brother, that if the simple description was a Black juvenile in a black hoodie, the Commonwealth would have a problem. But that is not what the facts below establish. And I would urge that.
What do you have beyond the fact that he's a Black juvenile in a black hoodie?
So first, I would point out that the tip itself was a young Black male dressed in a black hoodie and blue jeans, had a firearm in his waist, and was with another Black male in an off-white hoodie between Devon and Stanwood Street, which is one city block, on Columbia Road. And what I would turn the court's attention to first is that if this court looks at Exhibit 1, which is in the appendix at page 152, and reads the corresponding testimony related to Exhibit 1, this court can literally see that the difference between the barbershop where the juvenile was found and where Mr. Norwood was found on the corner is approximately 4 car lengths apart. They were near each other. The fact that they were not holding hands or shoulder to shoulder should not detract from a calculus of reasonable suspicion.
They weren't together, right?
Your Honor,
Do you concede that they weren't together?
I respectfully disagree. That I think it is.
Okay. So your position is they were together. That's your
I
position.
would suggest that a distance of 4 car lengths between.
Not what I'm asking you, counsel. I'm asking you, is your position that they were together? Yes or no?
It depends how the court wants to define together.
I'm asking you what your position is.
I would suggest that yes, they were together and that the police acted reasonably and that these people were separated by 4 car lengths half an hour after the tip came in.
And was Norwood also with Hollis?
I don't believe the testimony was that they were together, that Mr. Hollis and Mr. Norwood would.
Was Hollis closer to Norwood than was the juvenile?
Your Honor, respectfully, the record was not appropriately fleshed out with respect to that individual whose rights were not being challenged at the suppression hearing. And I would also point out turn the court's attention to the record at page 61, in which one of the officers explicitly testified on the record that no one else other than this juvenile matched the description that the reliable informant provided to the police.
Then why pat down Hollis? If that's true, why did they pat down Hollis?
Justice Desmond, I cannot answer that question on this record.
All right, so can't we question that credibility of that statement?
The credibility of
There was nobody else who particularly matched. I started with that. If it was so particularized, why did they start with patting down the guy with the black and the gray sweatshirt?
I would suggest they did not start there. And I would further suggest that the credibility determinations were for the motion judge to decide.
But I'm sorry, what testimony are you citing when you say that there was testimony that he was the only person who matched the description?
I believe it's at the appendix page 61, which is an officer's testimony that no one else in the area matched the description.
That's what he said.
Which office? That's what he said?
Mm-hmm.
Yes. And
beyond, but it defies credulity because they had already stopped 2 other people.
Well, respectfully, again, I would suggest that Mr. Norwood was part of the description provided by the confidential informant. And I would further suggest—
So he'd already stopped 1 other person. And the only way that you address that in your brief is to say, yeah, they did stop 1 other person who had blue jeans and a hoodie that wasn't quite black because it had gray on it.
Correct.
And now what you want us to, what you're implying, I think you've said it, is we don't know if he was stopped for some other reason. I did not pick that up. from the briefs. What I picked up from the briefs was, you know, they took a shot at this guy. He wasn't the right guy, and they were still walking around trying to find somebody else who matched it.
Your Honor, I cannot explain the reasoning for the stop of the gray and black hoodie when that person's rights were not being challenged at the suppression hearing and were not particular to the reasonable suspicion
What
calculus.
would be the Commonwealth's position on how many people in jeans and a black hoodie could have been stopped on that street at that time? Could they have walked around and stopped 5, 10, 15, 20 different people if there were people who matched that description?
The Commonwealth did not elicit testimony about the number of other people who were not stopped and
But
frisked.
isn't that a concern that we should have? I mean, this is what the Fourth Amendment is all about. Do you have the ability to walk down the street without being stopped by the government?
No, you don't.
No, we
Yes.
shouldn't be
No,
concerned
I
about how
apologize.
many
I mis-
people could be stopped
I
based
mis-
on this
I-
description?
I answered before Your Honor finished your question, for which I apologize. The individuals absolutely have a right to not be stopped and frisked by the police for no reason.
So, I'm sorry. So lucky for Hollis, he didn't have a gun. How is he supposed to challenge it? What's he supposed to file a civil rights violation?
I
He didn't have a gun.
am asking this court to focus on the tip as it pertains to the juvenile in this case. That's what I'm asking this court
We
to do.
cannot decide this case without evaluating the reasonableness of the officer's conduct, because that's what the Fourth Amendment tells us to do. And so in doing that, we have to ask the question, how if the Commonwealth's position mean that you could have walked down the street and literally stopped 20 different people because they had blue jeans and a black hoodie on? Now, we don't have any evidence about how many people had blue jeans and a black hoodie on at 5:30 in the afternoon on Columbia Road, but that's got to be a concern that we have to be asking. No?
I agree. And my answer to that is no, the police cannot stop anyone in a black hoodie and blue jeans.
Okay, counsel,
Not
I'm going to draw an easier hypothetical. Say there were 2 people inside the barbershop that had black hoodie and blue jeans. Could the officer stop one or both or none?
On that fact alone, I don't know that the officer could have necessarily stopped both, but what I will turn the court's attention to again in distinguishing this juvenile is that by the time the officers observed the juvenile, who they knew, and I want to preface this by saying I'm not asking, what I'm about to say is that Mr. Norwood was an affiliate of the Columbia Street Gang, as was the juvenile. And I'm not suggesting that this court take into account gang affiliation and all that might mean. But at a minimum, it does mean that these individuals were associated with each other. So to the extent that the tip suggested the individual in the white hoodie and the black hoodie were together, and the fact that the police responded and saw one member of an association, and then saw another member of the same association 4 car lengths away, who fit the description in that he was a young black male in a black hoodie and blue jeans, who was of the same association of the man in the off-white hoodie, who was 4 car lengths away on one city block within a half hour of a tip. I would suggest that that has to amount to reasonable suspicion.
So can I just slow you down for a second? You're saying things that I just want to make sure where I find them in the record. So
Sure.
One thing you're saying is the officer knew when he stopped the defendant that the defendant was affiliated with the Columbia Road Gang, and
Yes.
that the first person he'd stopped, Hollis, was affiliated with the Columbia Road Gang. Where are we going to find that in the record?
So it's not Mr. Hollis, it's Mr. Norwood, who was.
Oh, sorry, Mr. Norwood, yes.
So Mr. Norwood was a known member of the Columbia Road Gang, and that can be found on page, at the record 76. And as an aside, they also suggest that they knew him from an illegal gun possession in the past at page 52.
Is 270 Columbia Road across the street from the Fernandez barbershop?
Your Honor, I would suggest, I have information from outside the record that that address might not be accurately transcribed, but beyond that, even if you I'm not relying on that in the
I know,
relaxed.
I'm just asking, it's 270 Columbia Road across the street from Fernandez Barbershop.
I don't believe so.
Okay.
I don't believe so. But again, my position is that candidly, I'd suggest that's a red herring because the Commonwealth's not relying on that for this relaxed
I
regulation.
understand, but the judge mentioned it in his findings, right?
Yes.
Okay.
But I would
Are
also
there
say
any,
that fact was not contested at the hearing, and that the defendant is now challenging that fact, I'd suggest was more appropriately would have been put before the motion judge.
So the only testimony I'm finding on Miller's association is the question that's a leading question, unobjected to. And is Mr. Miller at that time, September 21, 2015, was he being associated after being a gang affiliate with the Columbia Gang Associates? Answer, that was my knowledge, yes. Is there anything more than that in the record?
The site that I have that the judge relied on is at page 58 to 59.
Okay, sorry. I had known him in the past to be a Columbia Road gang associate who resided on, okay. Okay, thank you. Now, the other thing you've said multiple times now, and I know you gave an explanation earlier, is that they were 4 car lengths apart.
Yes.
The person, and how are we to divine that from the record?
So it's in the defendant's record appendix at page 152 is a colored copy of the Commonwealth's Exhibit 1, in which I believe that the corresponding testimony was that an officer marked where he saw Mr. Norwood on the corner in the off-white sweatshirt and the juvenile in the barbershop at the second X, which is approximately, according to the photo, 4 car lengths away.
The 4 car lengths, a calculation done by your office or by you?
If you look at the photo, there's 4 cars in between the 2 X's.
Okay, it's a photo. All right, thank you.
And so just in sum, I understand the court's concern about Mr. Hollis's pat frisk. I would simply suggest that first and foremost, that the violation of someone else's rights should not detract from a relaxed, reasonable suspicion Aguilar-Spinelli test here. The tip itself, the only thing I would suggest was lacking is necessarily perhaps a name. And I would suggest that here they were together, the individual in the off-white sweatshirt and the black sweatshirt, given the proximate distance half an hour after the tip came in, and the fact that both of these individuals, Mr. Norwood and the juvenile, were known to each other. Were known to the police and were known to associate with each other. And given that, I'd suggest that there was at a minimum a reasonable suspicion to stop the juvenile here.
Thank you, counsel. Do either of my colleagues have any further questions?
I do not. Thank you.
Seeing none, thank you both very much. The case is submitted.
Thank you both.
All right, we are live and recording.
Thank you very much. We are back on the record. In our third case of the morning, it is Commonwealth versus Landry, 2019 P1340. And before I turn it over to Mr. Souza, I just want to remind folks that actually 2 things. One, the case is partially impounded, so please no references to the victim's name and so forth. And then the other thing is we have read the brief, so we're familiar with both the facts and the legal arguments. So I would urge counsel to the extent possible to cut to the chase. And with that, I will turn the floor over to Mr. Souza.
Good morning to the panel, to my sister. I appreciate the time. Again, I represent the appellant, Mr. Lee Landry, in this case. I'd like to jump, with the limited time that we have, I'd like to start by asking the court to review and interpret the Constitution as it relates to the case of Commonwealth versus Durling. In this case, the case we have here, Mr. Landry's case, we're asking that this court interpret Durling in order to find that there is a liberty interest in the increase in sentence imposed upon Mr. Landry, that liberty interest attaches to this defendant and all defendants dating back to the Durling case, for which I, excuse me, I'm asking this court to interpret that case.
Nothing in Durling suggests that it's about sentencing discretion, does it? Is there something in Durling that you're going to fix on that you want to point me to that tells me that it's about discretion of a judge to sentence within the punitive limits prescribed by statute?
In Durling, it does suggest that, and I also suggest that, and I've also cited to Commonwealth versus Martin.
Where in Durling does it suggest that it's about sentencing discretion within the limits of the amounts, the punishments established by statute?
Well, what I'm asking this court to look at Durling for is for the theory behind what it's proposing as a probationer is sentence brought in, that sentence is revoked, and upon that revocation, we have what amounts to an increase in a sentence. We had initially a probationary term, which the SJC has said is a liberty interest. It's curtailing our liberty to the point where we have to follow by the conditions of probation, and that's being revoked. And then in that case, in Durling specifically, the imposition of the sentence was a 9 months committed sentence. So effectively, what we had there was, again, looking back.
Well, there's no question that there's a liberty interest at stake, and there's no question that there's a liberty interest at stake when a judge prescribes a sentence. But to draw the parallel that you want from Durling to, you're arguing for something that, as far as I can tell, is not in our case law, which is that there's some kind of process that needs to be prescribed with respect to the information that a judge takes in to decide a sentence within the judge's discretion based on the punishment prescribed by the legislature, right?
Correct.
You want to put a process around that.
That process, I believe, also should attach to what parallels here in this case, which is an enhancement of the defendant's sentence. And take if for example, if in this case, and the case law is clear, if in this case there was just a discretionary sentence imposition on the defendant, then the courts have said, and agreeable, I would agree to that point, where they have discretion in order to sentence. But what we have in this specific instance is we have a judge who is unequivocally, and this was brought about in our motion to revise and revoke, unequivocally has said that he had relied upon the transmission of the STDs to the complainant from the defendant as the basis to enhance that sentence.
Let me ask you this question. I'm going to interrupt you for a second.
Sure.
So I'm not sure it was an enhancement just because it was a little bit above the guidelines, but still within the statutory limits. But aside from that for a moment, Durling dealt with the hearsay of the police report without bringing in live testimony. In this instance, the defendant moved to revise and revoke. This wasn't the Commonwealth bringing the defendant in before the court, right? It was the defendant who filed a motion to revise and revoke.
Correct.
And the judge is permitted, isn't he, to consider the victim impact statement. You don't quarrel with the fact that he heard a victim impact statement.
Yes, he did. And that victim impact.
And you don't quarrel with the fact that judges are allowed to hear victim impact statements, right?
I don't quarrel with that either. No, I don't.
Okay. And had the judge said nothing, had he just imposed the sentence, would you have said that it was impermissible?
Again, I brought the motion to revise and revoke after, the appeal for the motion to revise and revoke after the judge unequivocally said in his order, the specific issue of the STDs imparted on the victim by the defendant.
I understand. I'm saying, had he said nothing and just imposed the sentence that he imposed, would we be here today?
No.
Okay.
But I think he unequivocally acknowledges in his decision on the motion to revise and revoke that there was enhancement because he relies upon it. And
he acknowledges that the sentence that information was relevant to him and it was argued to him that certain information should be relevant to him in departing above what the guidelines say, but the guidelines are within the statutory maximum, right? I mean, what you're arguing for is interesting, but it has been rejected by our courts, by the US Supreme Court. You're arguing for some kind of process around the reliability of evidence taken into account by a sentencing court.
I would suggest that the courts are clear on the discretion of the judge in a setting where he's just imposing sentence. What we're suggesting here is when there's this additional, especially when we're talking about a case where it's expert testimony that would be required in order to first show that she had contracted an STD, and then that it was the defendant that had transferred it to her. That evidence, what we're arguing, is exceptional evidence. Citing back to the case I cited in my brief.
Are
Two
you saying
STDs, right? It's two STDs or one?
I'm sorry?
Wasn't it a combination of two specific type of diseases?
I believe so, yes.
And the sentence imposed was less than the statutory maximum, right?
It was less than statutory maximum, but above what would be considered the guide. The guidelines is only guidance. I understand that it's not precedent, it's not binding law upon the judge to sentence. But what we have here is a judge that had unequivocally say, I'd enhance the sentence. And even if you refer to the sentencing guidelines, it imposes a suggestion that when there is a departure from the guidelines, that there be some kind of writing, that it be some kind of indication from the court, the evidence that he or she relied upon and how that applied to the
But you're admitting
that
that happened here. The judge did rely on it. You just think the judge relied on something that wasn't sufficiently reliable. You think that there
and I
needed
believe
to
that
be-
I believe that parallels Durling, because we're specifically in the theory of due process, where we're saying that there is an increase
Except
in
that
sentence.
Durling has Supreme Court cases behind it called Morrissey against Brewer and Gagnon against Scarpelli that say that due process applies when you're revoking probation. In this case, you got Apprendi, which says the judge has discretion, and as long as they're below the statutory maximum, we're not going to apply these kinds of restrictions that you're talking about.
The theory behind Durling is the fact that there is a liberty interest lost in a greater sentence that's imposed after revocation. That same theory should apply, and I'm asking this court to interpret Durling to interpret the SJC's ruling in Durling and apply that here, where we have a case where there is an enhancement, and especially again, where it's expert testimony that the judges rely upon to increase that sentence.
So I don't know the answer to this question because I'm less experienced than other members of this panel, but I assume that there's information taken in at sentencing from time to time that might be something that an expert would have to put in if it were evidentiary. For example, a defendant's mental health, or information about how a defendant has, well, let's take that. Let's take mental health, for example. I mean, don't judges on sentencing have broad discretion to listen to information that ordinarily might have to come in through an expert, but that doesn't?
To the extent that we fall back on the case law where it says, where do we get the line where I believe I included in the brief that needs to be drawn is whether or not, and I believe it was the Martin case where it says it's wholly unreliable evidence. We have just hearsay statement from the complainant saying this occurred, and then we're having the Commonwealth follow up on that and say, yes, this STD occurred. And the judge therefore saying, well, as a basis of my enhancement.
That goes to a whole second level of issues, which are, was the information sufficiently reliable, even if we were applying Durling? Here, it was reported that this was testimony before the grand jury. Isn't that sufficiently reliable under Durling?
I don't believe so, because that's a probable cause standard in order to determine what and
testimony given under oath and recorded.
But there's no opportunity to rebut, no opportunity for cross-examination. A lot of times, what we're saying is we've got the boundary threshold there is probable cause. I'm saying it has to be more than that. If we look at Durling, it's about preponderance of the evidence. That evidence needs to be reliable, at least to that threshold. I'm not suggesting one way or another that it has to follow Durling step by step, but I believe that there is there is precedent there to suggest that.
Under Durling, my understanding is that under Durling, grand jury testimony is sufficiently reliable to pass the test because it's testimony that's recorded and given under oath. And are you familiar with the decision that came down from this court within the last month called Commonwealth against Costa?
I have to say that I'm not. I don't.
There was a dissent in that case written by somebody I know well, but the majority, and I think also the dissent, accepted the notion that grand jury testimony was sufficiently reliable to pass Durling.
Without knowing the backlog of that case, I would ask the court more of a question than I would of a statement, is to suggest that was that in the standard sentencing? In other words, was there an enhancement?
No, that was in a probation revocation hearing.
Similar
where
to
we
what
were
would be in
applying
Durling.
Durling directly, and we said grand jury testimony is sufficiently reliable. But there was no dissent from that.
Well, I think reliability determination has to, and the case I have here.
Well, while you're looking for that, wasn't it his sister who testified? The sister of the defendant and the mother of the victim?
Yes.
And isn't there record support that the sister of the defendant and the defendant himself were friendly? There was no animus between them, those two, right? In fact, she's the one, I think, who took the defendant to the hospital when he had to go.
Yeah, they had a very close relationship from what I understand from the record.
Counsel, just taking a different hypothetical, one that doesn't involve expert issues, but just an ordinary mundane case where a defendant's arguing against jail time, saying he's got an elderly mother he needs to take care of. Prosecutor stands up and says, Your Honor, I don't think he's got an elderly mother. So there's a dispute of fact on an issue that's relevant to sentencing. What's the judge supposed to do in that context?
Well, I'm only asking for the court to consider it in the context of an enhancement rather than just the sentence that's imposed. I give the example that for example, if there was already expert testimony during trial that had made that indication that there was a transmission, and the court said, well, I rely upon the trial evidence, then I would say that we wouldn't even be here either. But that didn't happen. And the reason I look at Durling is because there is no precedent as to when a court goes beyond what it considers to be an otherwise sentence in conjunction with the sentencing guidelines, and unequivocally says that they've enhanced it. And to look at what that evidence is, to consider it as a whole, and each one is considered in isolation, it would be very, very minimal circumstances I suggest that this would apply. A lot of times you'll have it in the evidence. A lot of times that'll be brought forth and it'll be considered reliable because of other considerations. But the strength of this evidence of being expert in nature, and to come to the conclusion that I've enhanced this sentence because of that, of not the knowledge of that STD transmission without having expert testimony at any point, would suggest that in the minimal, the court should apply due process to that, to say at least allow the defendant to make that, to rebut that notion that existed. There was also determination during trial where the defense counsel suggests we have a dispute with that STD evidence. It hasn't come out because of tactical considerations and agreements at trial, but that doesn't mean that it shouldn't be applied in the sentencing phase when we're losing our liberty. It's just a protection in those instances, again, where Molino had said, wholly unreliable evidence. If it's wholly unreliable in the case where you're having an expert opinion without any kind of challenge to that, any kind of challenge to what that opinion details, even if it's in the guise of probable cause in a grand jury setting, I would suggest in this very limited circumstance that it should be applied with a little more scrutiny. And I see that my time has expired. I rest on my brief if there are no more questions from the panel.
Seeing none, I was just going to state for the record that I was sure that Judge Englander was retrieving a book and not leaving the premises, but that was confirmed by the video. We will hear from the Commonwealth.
Good morning. May it please the court. My name is Emily Walsh. I'm Assistant District Attorney from Middlesex on behalf of the Commonwealth. This case comes to the court as an appeal of the denial of a motion to revise or revoke, which is reviewed for an abuse of discretion. The defendant doesn't claim his sentence is illegal. It doesn't go beyond the maximum legal sentence. The judge made it clear what he relied on during sentencing, all of which were valid legal sentencing considerations. The defendant had ample opportunity to rebut the STD information. He had an opportunity to rebut that information at the sentencing hearing, and he had.
How would he have done that at the sentencing hearing?
He could have brought in medical records. He could have had brought in an affidavit from his provider, something to show that he doesn't now. And if he sought medical treatment closer to the rapes, to show that he did not have those STDs then, or that he does not currently have them. He introduced nothing.
Let me just ask you one question. Didn't he have an expert who was either prepared to testify or perhaps submitted a report that the defendant's STDs were a year prior to the rapes?
So he had an expert who he put forth pre-trial that if this became an issue at trial, he was going to call this expert, and the expert was going to say that a year before the rapes, he did not have the STDs. However, at sentencing, he didn't provide anything from that expert. His offer of proof at sentencing was, we dispute this. That was it. He had the opportunity to put in materials to support his position that it wasn't true, and he didn't do that. He had the opportunity again in his motion to revise and revoke, and instead he says in an affidavit that, quote, at my sentencing hearing, the complainant claimed that I had transmitted a disease to her. There was no evidence presented at trial of this being true. That is what he said in his affidavit for his motion to revise and revoke. He could have then said, that is not true, and I have information to back it up, or at least assert that it's not true. He didn't even assert it wasn't true. He said, no facts confirming that came in at trial. The offer of proof made at sentencing was not enough to rebut what the Commonwealth put forth. And then he offered.
So that's an argument. That's an argument at the second level, right? That's an argument that says it just wasn't shown that there's a sufficient basis to really be concerned about the reliability of the evidence the judge relied on.
Right.
I take it that the Commonwealth doesn't think we need to get to the second level.
That's correct.
Commonwealth's position is that the judge, that there's no process, if you will, around what is or is not to be considered by a judge at sentencing. There's no reliability threshold.
I wouldn't say that that's entirely true. The defendant has a right under Chapter 279, Section 4B, to rebut the victim's oral or written statement at sentencing. So there is some degree of process for the
defendant. But there's nothing that limits what the judge can listen to only such evidence as is sort of meets a threshold of reliability.
I would say if a judge relied on blatantly unreliable evidence, especially where the defendant offered something to rebut it, then that's a proper basis for a Rule 29 motion. But I agree with what you're saying.
Under what theory? That it's unconstitutional?
No, just that it's not fair. That Rule 29 says that if a judge considers something that the defendant can show was unreliable, I think that that's a basis for a motion under Rule 29, that he abused his discretion in considering something. Like if the defendant had medical records that blatantly established that he had never had any STDs in some way.
Or if the Commonwealth asserted convictions that it turns out never occurred.
I mean, that's the basis for our appellate process, right? Something unfair happened at trial or at sentencing, and then it's put forth, and the defendant.
But that's not a constitution. I mean, the only reason that this issue can even be raised at this point is because he's arguing that it's unconstitutional. Otherwise, he's got to do it within 60 days, and they didn't bring the motion within 60 days, right? Right. So his argument has to be a constitutionally based argument.
The defendant had the opportunity to be heard that he was allowed under our rules. He did not present anything. He made an insufficient offer of proof. He didn't produce anything meaningful in his motion to revise or revoke. And the judge acted within his discretion when he relied on the representations at sentencing. Furthermore, the sentence was just, and the court made it clear that while he relied on it, the primary things that he relied on were the particularly cruel and brutal act and the long history of felonious behavior. The sentence was just. Are there any further questions from the panel?
Your brother has cited a case, and I thought it was this Molino case, for the proposition that there is some sort of limit reflected in the SJC case law on if the information is, clearly incorrect or something like that, that it would be improper. What case are we? I couldn't find the language just now in Molino.
I did find in Commonwealth versus Enrique, 56 Mass Appeals Court, 775, 2002, that information used at sentencing should be relevant and, quote, sufficiently reliable, which I think just goes to sort of the fairness standard, that if a judge considers something that's blatantly untrue, like my hypothetical.
Right, but part of the reason I'm asking these questions is because there's a very important procedural issue in the middle of this, which is once 60 days have passed, it has to be unconstitutional. And so, is that standard a constitutional standard? Nothing that I can find suggests that it's a constitutional standard.
I don't think it's a constitutional standard, but going back to this case, the defendant still has not put forth anything to show that the Commonwealth's representations were unreliable. He doesn't contest that what was represented to be in the grand jury minutes is in fact in the grand jury minutes. What he contests is that he claims he didn't give the STDs, but he's never, that is something that could be proven conceivably.
I'm still listening, so don't worry.
He's put forth nothing. He had two opportunities to do so at sentencing and in his motion to revise and revoke. Even if the judge credited the defendant's affidavit, all it says is that nothing was introduced at trial about the STDs. And that's accurate because it was by agreement.
Well, counsel, to what extent, if at all, are you relying on the fact of an alleged agreement between counsel to keep this out of the trial evidence?
I'm sorry, I don't understand the question. They agreed to keep it out and they kept it out.
But my recollection of the record here is that when this issue came up, counsel for the defendant said, no, that's not the nature of the agreement.
No, there was a motion in limine hearing. I believe it was like October 27th, and the defendant said, I have an expert that I would put in, and the Commonwealth I believe it was by agreement in the end that they decided not to have the STD evidence come in at all. It was, the Commonwealth asserted that it would be embarrassing for the victim.
Okay, but is that agreement on the record here? Is it shown in the record?
I think it's on the docket. I think it says motion in limine to preclude mention of STDs allowed by agreement, and it's uncontested.
I'm sorry to interrupt you. Did I read that in your brief, or did I read that in the transcript?
It may have been both. I did mention it in my brief, but it's not contested. I think the defendant agrees that nothing about the STDs came in at trial because it was the subject of a motion in limine, and it was excluded by agreement.
Did you include the recitation of that conversation at sidebar from the prosecutor? Because I read the prosecutor's interaction with the court on that issue.
So I believe the sentencing hearing has a sidebar about the fact that the STDs didn't come in by agreement. I believe it's in the sentencing transcript, and I know I referenced it in my brief.
Struggling because it looks like I misunderstood Rule 29. I was doing it from memory and I got it wrong. How are we within 60 days? How is this motion within 60 days? And doesn't it have to be within 60 days?
I did the math. There's a footnote about when the rescript issued because it was closed.
Oh, it's within 60 days of the issuance of the rescript.
Yeah.
Okay. All right. Sorry. Yeah, I thought for some reason that because it was constitutional argument, that was the only way out of the. Okay. Got it. Thank you.
Are there any further questions from the panel?
Seeing none,
The real issue in this case is whether it was an abuse of discretion to consider the STD evidence as one of many factors in the judge's considerations, and it was not. If there are no further questions, I would rest on my brief.
seeing none, that'll bring us to a close. Thank you both very much. The case is now submitted.
Thank you.
We have read the brief, so we are familiar with both the facts and the arguments. And with that, I will turn the floor over to Attorney Woodruff.
Thank you, Your Honor. Good morning. May it please the court. My name is Lee Woodruff, and I represent the appellant, Roland Constantino. Before talking about my client, I'd like to start with 3 short but important quotes. Quote 1, alcoholism is a disease characterized by chronic, habitual, or periodic consumption of alcoholic beverages, resulting in the loss of powers of self-control. Massachusetts General Laws, Chapter 111B, Section 3. Quote number 2, alcoholism is caused by something other than the moral fault of the alcoholic, something that cannot be controlled by him. Justice Abe Fortas, citing medical authorities in his dissent in Powell v. Texas in 1968. Quote 3, alcoholism is a chronic, relapsing brain disorder characterized by impaired ability to control alcohol use, despite adverse social, health, or occupational consequences. National Institutes of Health. My client, Mr. Constantino, has been plagued by the disease of alcoholism for over 40 years.
Do you agree that alcoholism is not a bar to denial of benefits?
No, Your Honor, alcoholism is not a bar to denial of benefits. Mr. Constantino, like several of the claimants in the various Board of Review decisions, sought treatment multiple times over the years, and he was in recovery, sober for a long time. But then his father died and the disease relapsed. Somehow, after the relapse, he still managed to function, and he preserved his employment for several more years. His alcohol manifested in periodic consumption, to use the legislature's term from Chapter 111B. He did not drink during the hours he drove for the lumber company, but practically the moment his workday ended, the disease overpowered his self-control. Mr. Constantino drank compulsively, starting during his drive home from work. The disease robbed him of the power, the self-control to do otherwise.
Doesn't he make a statement at one point where he says something like, I forget exactly where I read it, but he says something like, I'm one of those guys who can drink and it doesn't affect my ability to drive or to function. Doesn't he make a statement like that?
Yes, he made some statement to that effect, but it really does not affect the analysis here. Mr. Constantino was not drinking and driving while he was working. The question before the court is really whether the alcoholism undermined his ability to make the decisions to consume alcohol. Was he compelled to do so? And all the cascade of events that followed, including the driving.
I'm not sure that that is the question before the court. And that's why this case is kind of interesting, right? I mean, there are these 3 cases, this trilogy of cases that get cited to us that go back many years. And how the statute gets applied, it seems to me, depends very much in those cases on whether the person was discharged from work or whether he left work voluntarily, because those are the statutory words. Leaving aside that additional sentence that comes, 1 paragraph later. Did your client leave voluntarily or was he discharged?
My client left work involuntarily. He, as you can see in the testimony, both he and his employer agree. There was never.
So you're not taking the position that he was discharged. You're not taking the position that he falls under E2.
Correct, Your Honor. I'm not taking that position. We've decided to focus our argument on the fact that his leaving was involuntary.
Involuntary as a result of being such an urgent, compelling, and necessitous nature.
Yes.
Right?
Yes, and also that it was simply involuntary because of the alcoholism that deprived him of the ability to act in a voluntary way. And I will say to Your Honors that clearly there is a need for appellate case law in this area, interpreting the statute further.
Well, it's interesting that you're playing a semantic game with me when you say involuntary but not discharged. I mean, and the semantics may be important. The exceptions are whether he was discharged voluntarily, unless he establishes certain things. You're not taking that position. Voluntarily, unless he had credible evidence of good cause. It's not E1. And he wasn't discharged, so it's not E2.
Right.
Okay, but it's got to fall under involuntary, which means you need to show, it seems to me, the predicate to that of such an urgent, compelling, and necessitous nature. His leaving was of an urgent, compelling, and necessitous nature. Or are you positing yet another category, involuntary but not urgent, compelling, and necessitous?
I think, Your Honor, we're arguing both. And in positing the category of simply involuntary leaving, that's not a discharge, I would direct the court's attention back to the board's decision, the Board of Review in 2011 in 117836. There, the then current members of GUA's Board of Review approved benefits for another commercial driver who lost his driver's license due to drunk driving. And just like my client, that driver had suffered from alcoholism for many years. Just like my client, that driver suffered a relapse after his father died. And he consumed alcohol and drove his private vehicle, which led to the loss of his license.
So which category did he fall into?
Yes, and he also was admitted to detox after. And the categories—
Which category did he fall into? Which category did the board say he fell into?
The board held that as a matter of law, the claimant did not voluntarily leave his employment and he may not be disqualified under Section 25E1. Now, alternatively, the board said it was a mitigating circumstance, and decided the case, I think, alternatively under E2 as I read it. But I think there is this middling category of involuntary leaving. Now, maybe—
What does it have trouble convincing this judge that there's another category that doesn't correspond to the language of the statute?
Yeah, and maybe what they meant to say—
The board's decision is not binding on us, right?
Of course,
What
of course.
if
But
he
maybe
was—
what the board meant to say in that case— Oh, I'm sorry.
Go ahead, let me let you finish your answer.
Maybe what the board meant to say in that case was because that person had these events happen in his life, these personal reasons that the courts have recognized are sufficient, and he went into detox after the arrest, that was urgent, compelling, and necessitous, although they did not reach that.
What if he was drunk because or intoxicated because of alcoholism and committed the domestic violence for which he got sentenced to prison? And while in prison, he took alcohol classes. Would he be entitled to benefits?
No, Your Honor, for several reasons. The unemployment statute is very strict. So somebody can only be eligible if within the last year they had 8 weeks of work at the level of their benefit. So if someone had been impaired or incarcerated for a long time, they would not qualify on that basis. And it's important to note that the statute is remedial in nature, unlike the criminal statutes. It's not intended to punish or to protect the public from drunk drivers or other crimes. It's remedial. And that means healing, curative, and
Counsel-
restorative.
Counsel, we understand that argument.
Mhm.
How do you address the fact that even Shepherd, which came up in a different context, places some responsibilities on the employee in terms of, in that context, not refusing a remedial step offered to him to address the alcoholism, or actually drinking, it wasn't alcohol. No.
Right. So he did claim alcoholism in that case. And what the worker in that case, the issue was, did he refuse help? That was what the remand was for.
But you would agree that that does place some responsibility, call it moral responsibility or something else,
Yes.
for the employee to address his situation.
I think when we say situation, or as the board said here, problem, it maybe mischaracterizes alcoholism and into that category. I do think that Mr. Constantino had, like others in the cases that we've cited over the years, taken extraordinary steps, including hypnosis and seeing many doctors, taking multiple medications.
This in the record?
Well, I believe that his attorney at the hearing mentioned the hypnosis, and there was mention of medication.
You said a number of other things that were similar, that he didn't drink it all on the job, but he started the moment he left. And
Yes.
I didn't find those in the findings of fact. And therefore, I'm trying to figure out where I should go for what you're telling us now.
Okay, that is in the testimony from the second day of the hearing, I believe at around page 10.
Okay.
Mr. Constantino's own testimony.
Counsel, to what extent are you making the agency move the goalpost argument here? And to the extent you are making that, to what extent is there either things in the record you would point to, or things you would have put in the record had you known the standard had changed?
If I had been the counsel at that time, I would have probably included more medical history records for Mr. Constantino, which we would do if this case were remanded for a new hearing. I would try to think what the board meant when it said sincere efforts, because there's really no definition of that in any of the cases. I think this goes back to one of your questions. What does a person have to do? It's unclear in any of the case law and any of the Board of Review decisions. Where is the line? What is sincere? And what does a person suffering from a disease, alcoholism, that affects his willpower and his ability to control his behavior have to do to act in a sincere way?
So
Doesn't the case say it's fact specific to the case? Isn't that what I think Shepherd says, or one of them, Onita, one of them, I forget which one, but one says, we can't really make the broad rule. It's really very fact intensive with respect to each case by case. So here, what was Mr. Constantino, is that how you pronounce his name, by the way?
Yes.
What did he do to address his alcoholism in the year preceding his arrest? That's in the record.
It's not as clearly in the record as I would like. There do appear some medications that are for suppressing cravings in his discharge papers from the AdCare detox facility. And as I said, I believe that his counsel mentioned the hypnosis he was doing in 2017, 2018, but that's not testimony. So I can't direct you to that, but he was in treatment. And as I said, he had been in treatment for many years as the disease ebbed and flowed as it's wont to do.
So it's just Desmond asked a question right off the top. Does the alcoholism absolve him from, I don't know if this is exactly the way it was asked, but that's the way I heard it. Basically, is your contention that if he's an alcoholic, then that means there's not a basis for rejecting benefits. And you, I think, sort of acknowledge, no, it has to be more than that. You're not taking the position that any alcoholic is sort of absolved from having his benefits not granted. So
Correct.
how are we to draw the line, since a line has to be drawn?
Correct, Your Honor. I think I would direct the court again, and I know it's not binding, but it was informative to, I think, my brother counsel who represented Mr. Constantino, the BR 117836 decision. That person, like Mr. Constantino, entered a detoxification program of 2 weeks directly after his arrest and before he applied for benefits. After that discharge, both of these people continued going to outpatient treatment. They did Alcoholics Anonymous, and I can happily report that, like that person, Mr. Constantino remains sober to this day. So they did take action both before in fighting the disease over the years and after, immediately after.
Was that the Casey? Was that Casey?
No, that was not Casey. That was a district court decision. I think it's called Carey, actually.
Okay.
But the one that I'm citing is the board's decision 117836, which is contained in both parties' papers, I believe.
I saw it.
Okay, I'm sorry, may I ask one more? Sorry, Judge.
Of course.
You know what? It's just gone completely out of my mind. I'm sorry. Why don't we can move on?
Okay. Well, if there are no further questions, I'll rest on my briefs. Thank you.
Thank you very much. We will hear from the agency.
Thank you and good morning. May it please the court, Assistant Attorney General Michael LaFleur, appearing on behalf of the appellee, Richard Jeffers, Director of the Department of Unemployment Assistance. The department asks that you affirm the district court's determination upholding its decision in the appellant's case. Here, the department's undisputed findings are that the appellant initiated a series of events that resulted in the suspension of the commercial driver's license that was necessary for him to do his job as a truck driver, causing him to tell his former employer that he could no longer work there. It was not an error in the circumstances of this case for the department to have rejected the appellant's contention that his separation from work, and by implication his CDL suspension, were rendered involuntary for urgent, compelling, and necessitous reasons because he also suffers from the disease of alcoholism. Nor was it an error for the district court to have affirmed that determination in the Chapter 38 judicial review that was confined to the administrative record.
I take it the board and the Commonwealth do not take the position that simply because he lost his license, that's the end of the story.
Certainly not, Justice Englander.
Well, why do you say certainly not? Because once you say certainly not, then it seems to me that we're dickering price. We're into the, I mean, it seems to me the position could be taken. Hey, this was voluntary. And the reason it was voluntary is he did something that caused him to be in a position where he could not do his job anymore. And it seems to me that that's not the position that's being taken. Instead, the position that's being taken is that somehow we have to look at what the claimant did or did not do to address alcoholism and make a judgment as to whether that was good enough. Is that the position of the Commonwealth? And if it is, how do we do that?
That's not the position of the Commonwealth. Again, this is looking to the administrative record and the arguments that this appellant specifically made through prior counsel. He relied on Section 1216G of the Service Representative's Handbook. And again, just to back up for a second, the statutory provision in issue does not purport to define any particular urgent, compelling, or necessitous reason that might render a decision to leave a job involuntary. The legislature, in the plain language of the statute, expressly left it to the department to define those terms, and the department has done that over the decades through case-by-case adjudication by its board of review, often involving—
How was it expressly left to the department? I mean, I see the language, I'm looking at it right now. It doesn't say, and the department shall define that. So
it says to the satisfaction of the commissioner shall show to the
Okay,
satisfaction of
thank
the
you,
commission.
thank you, got it.
So the case by case adjudication, but additionally, there's this thing called the Service Representative's Handbook. The appellant himself, which is a sub-regulatory guidance, if you will. The appellant himself here, but through prior counsel, cites section 1216G of the Service Representative's Handbook. And this decision is very much an interpretation of section 1216G. So I would draw your attention to the language of section 1216G.
But that's guidance, right? That's not notice and comment rulemaking we're talking about.
Correct. But the LeBeau decision by the SJC in 1996, which I cite in my brief, does give deference to the agency. Certainly,
Even for guidance?
It is, yes, specifically for the handbook. Yes, LeBeau said that I quote, as the agency charged with enforcing the unemployment compensation laws, we give substantial deference to the department's interpretation in the handbook.
Okay, counsel, in the ruling below, the administrative ruling, the board put great emphasis on the part of the standard that says we're going to look at the time of the infraction what the employee was doing to address the alcoholism at that time, where there are sincere efforts to address it. That timing aspect was not the law at the time of the hearing, correct? That was decided in a different case that came down after the hearing.
The department does not concede that at all. The department does not concede that this was a new formulation. And in fact, explicitly in its decision, there is a statement on the top of page 6, the first sentence of page 6 under the decision, which is reproduced variously in the records, that this reasoning is not new. So again, it's important to keep in mind, and if I could just quote from the language of 1216G, which I reproduced in my brief at page 267, that under that section, if a claimant admits that he or she is an alcoholic and is making a sincere effort to overcome the alcoholism, such leaving will be considered an involuntary separation. That's in the handbook. That's this provision that the claimant himself cited here. The only language that the board added in the decision was the words before the incident that caused him to lose his job. The board's position is that that's an entirely consistent application for how it has interpreted Shepard in the discharge context.
Okay, but counsel, there is no question, tell me if I'm wrong, that this employee, there's all sorts of stuff, even in this record, that the employee was dealing with alcoholism for decades, and at least for a period, largely had it under control. And so the evidence that he had been taking steps to control it is there. And hence the focus on, okay, you may have done this decades ago, but what were you doing at the time you lost your license? That was a primary focus of what the board said. And isn't that timing new for the board?
So, no, Your Honor, on both premises, so the department, the department doesn't accept that there is evidence in the record of prior efforts at all. There's no, this indication of hypnosis, I don't see that there. The notation in his discharge summary that was cited for the first time to the district court that a medication called gabapentin could have been used for treatment, that's certainly not apparent on the plain record. That gabapentin is for alcohol treatment. There was no evidence of alcohol treatment. The record was that he had been an alcoholic for over 40 years. The board's position is that the only evidence of mitigation, if you will, in this case, is alcoholism, and it's certainly not disputed that alcoholism is a serious disorder. And the board was not saying that alcoholism disqualifies someone who quits their job because of an off-duty incident. From benefits in all instances. It was what it was doing was rendering a decision that was consistent with a long-standing, approval by the judicial overlay in this area for taking efforts to preserve employment. I think instructive is the Norfolk County Retirement System's decision by this court in 2006 in that regard. But there's no evidence of prior efforts, in my view, in the record. The evidence was that he had, pardon me, Justice Desmond.
This defendant, he had an alcohol-related issue with this employer prior and then returned to work. Is that true?
Correct, Your Honor. The finding was that he was arrested for OUI in February of 2018. He took a breathalyzer test and as a result lost his driver's license for 30 days. He took a leave of absence and then was allowed to return to work. And then in June of 2018, he was again arrested for operating under the influence of alcohol. And there's a finding that he, in effect, he did refuse the breathalyzer test. There was a great deal of back and forth at the administrative level about whether or not this was a refusal. But in effect, there's a finding that this was a refusal and that he lost his job because that he separated from work because he told, there's an undisputed finding that he told his former employer, and there was a considerable amount of disputed testimony about this, that he could no longer work there. There was a specific finding. The claimant told former employee, this is finding 25, he could no longer work there because his license had been suspended for 180 days. So this is thus making this very clearly a voluntary discharge case where the burden is on the claimant to show either that he left for a good cause attributable to the employer, which was not attempted here, or that this was a necessitous leavings area. That's paragraph 3 of section 25 in the unemployment law. And that's an area, the necessitous leavings area is an area of law that is very much committed to the discretion of the board. And what the appellant here is asking this court to do is to say, just because he was an alcoholic, that rendered his decision to leave involuntary. And the department's position is that it was not an error, particularly given the case law overlay that requires prior efforts to preserve employment. That's long, going back to the 1974 decision in the Raytheon Company case that's cited in my brief. Prior effort to preserve employment before the separation is a prominent factor in the determination about whether or not a leaving was necessitous. And
counsel, your sister in her briefs makes arguments that what the board did here is inconsistent with what was done in other administrative proceedings. Your primary response to that in your brief is the department is free to change its mind, and that's what it did here. To the extent that the department changed the standard, why shouldn't this employee get a chance to show that he met the new standard?
And for that, that was poor wording on my part. As I tried to make clear in this argument, in the plain terms of the board's decision, it does not concede that this is a new standard. I did not mean to imply that the board was issuing a new standard. What I was getting at in that footnote was to the effect that there's certainly, it's been a longstanding principle that the board can announce policy by adjudication. And that doesn't, in and of itself, in the 30A review context, make a decision erroneous.
But no, that's not what I don't think that's what Justice Milkey's asking.
Pardon me.
I think it's something different. You are suggesting that deference is due to the construction that the board gives to this urgent necessitous language. If the board has not been consistent in how it's applied that language, then I think the case law and administrative law cases will tell you that deference is less likely to be applied. And I'm actually those lines I'm sorry, can I just finish this? Is your sister right that there's an opinion from the board which, as she outlined, would mean that this case would come out the other way?
There is, but I think that is dealt with very adequately in footnote 2 of the board on page 6 of the board's decision. See, in that decision that my sister cited, I think it's 11736 of 2011. It's a decision by a prior board. In that case, the initial hearing, to which that claimant was entitled as a statutory right, resulted in a finding that the person had quit, and that this was a hearing where the employer didn't attend. So then, when it got to when the claimant in that case appealed to the board of review, the board accepted the application for review and determined it declined to adopt the finding of a quit, and it found that there had been a discharge, and that Shepard governed, and that because the employer did not appear, there was no evidence. There was no evidence that that could satisfy the standard in a discharge case. What in footnote 2 of the decision on page 6, like I think it's something like maybe page 215 in the appellant's record appendix, is that it was wrongly decided as a discharge case. I think there can be no question in this case that we're in the voluntary separation arena. This is that any argument that this should be a discharge matter is gone. This again is, and this is again a case I would ask the court to keep in mind that this should be decided on the administrative record. There were only 2 prior board decisions that were cited, or 3, but only 2 that are now pressed, that were cited to the prior board, to the board in this case, and the board dealt with both of those decisions. To the extent that there's now an attempt to show that this decision was arbitrary and capricious based on other decisions, the board was never given an opportunity to discuss those decisions, and it does not concede that those decisions were in fact inconsistent. I could go through them if Your Honor wished, but in effect,
well, no, I'm looking at them now. I mean, I see footnote 2, and I also see at the top of that page a citation to 3 cases that come after the 2011 decision that you're talking about. That at least the board is citing them as if they applied the same standard that you're advocating for here.
Yes, Your Honor. And the board's point there is that in all those 3 cases, the emphasis was on prior efforts to maintain employment. And I think that this, under the circumstances of this case, it's clear that the employee was on notice, the claimant was on notice that his CDL was in jeopardy. After the February 2018 arrest, there was no evidence of any efforts to control the alcoholism until after he lost the license, the CDL that caused him to tell his employer he could no longer work there. And seeing that my time is expired.
Counsel, just speaking for myself, I have one more question. What does the word sincere add to the mix?
So again, this is an area where this is the board. It's the board's articulation of. It's difficult for me to answer that because these decisions are so fact intensive. It is in this case where there is no effort of there's no evidence of prior efforts. There's not a case where there's an administrative record that would require this court to determine the level of sincerity of the prior efforts and whether or not that quantum of proof was sufficient. Here, the findings were not challenged. The challenge is to whether or not the board, as the standard that the board applied, my point as to deference is only that standard is entitled to that. They're entitled to apply their own standard. And in this case, there's no evidence since there's no evidence of any effort prior to the incident causing separation. It's just not a matter where that quantum of proof could be called into question, and whether that.
Okay, Counsel, I'm going to stop you there on that. Do either of my colleagues have any further questions? Seeing none, thank you both very much. Very interesting case, which is now submitted.
Thank you.
All right, we are live and recording.
Thank you very much. We are back on the record for our 5th case. It is still the morning. 2019 P 1755 Pierce versus Lyons. I would remind counsel that we have read the briefs, so we are familiar with both the underlying facts and the arguments. So I would urge both counsel, to the extent possible, to cut to the chase. And with that, I will turn the floor over to Attorney Cox.
Thank you very much. And may it please the Court, Attorney Bill Cox, representing Jeffrey J. Pierce, who's the personal representative for the estate of Donald A. Pierce, the appellant in this case. This is a basic contract case. The plaintiff is seeking to enforce the provisions of a collective bargaining agreement, which provide retirees, former employees, with a specific benefit. The benefit is called an end of career policy. And there are several qualifications for that. You have to have been a professional staff member. You have to have had 10 years of service, attained the age of 55, and or otherwise qualify for retirement benefits upon termination of employment. And you have to notify the superintendent 4 months before retirement. All of which Mr. Pierce did or qualified for at the time of his retirement. The lower court misclassifies Pierce as an employee. It's clear that pursuant to Mass General Law, Chapter 150E, Section 1, which defines employee, as well as the collective bargaining agreement itself, that Pierce, who voluntarily resigned on June 24th, 2010, after 25 years of service from his position as a full-time classroom teacher, was no longer an active employee. The U.S. Supreme...
He voluntarily resigned in the face of misconduct, right?
Well, I understand, Your Honor, that the appellee wants to make that case, but I don't think there's a distinction here. All that the collective bargaining agreement provides for in terms of qualifications is employment termination. I would submit that even if he had been fired, which was not the case here, he voluntarily resigned, he still would have qualified for this benefit.
Well, he didn't qualify at the time of his termination of employment.
Yes, he did, Your Honor.
No, he wasn't 55 yet.
But, so that's the argument that the appellee keeps making. And what he chooses to ignore are the words and or. So, as Your Honors might be familiar with, under Chapter 32, the retirement system for the Commonwealth of Massachusetts and its subdivisions thereof, specifically Chapter 32, Section 10, which provides for superannuated basis. So there's two ways that an individual can qualify for a retirement benefit. You either have to have attained the age of 55, which I would agree with Your Honor that Mr. Pierce was not 55 at the time he resigned, or you have to have 20 years of service. At that particular time, Mr. Pierce had 25 years of service. He was entitled to retire at that time. He chose not to because, as Your Honors might also be aware, one of the three factors that determines your retirement benefits is your age. So the longer he waited to retire, the more he would receive in benefits.
So it's interesting, you neither the court nor you addressed this point in the briefs, and so it's the first time sort of putting my head around it. So your position is he qualified for retirement benefits, but he didn't retire.
At that time, no, he did not retire.
Okay. And so when he did retire, you say this is a simple breach of contract case. When he did retire, what contract are we asserting under?
Well, the 2008-2010 collective bargaining agreement.
Which had expired. Right.
Well, I understand that's the argument that my brother wants to make, that these contracts somehow expire and try to make this analogous.
Well, they do more than somehow expire. I believe the language is that they expire. So you have to say, sorry, go ahead. I'm sorry.
No, there was a superseding agreement. Do you contest that?
When you say superseding agreement, Your Honor?
After the 2010 CBA expired, there was another,
correct,
for lack of a better term,
a successor agreement.
Yes.
Yes. Yes.
But you're not suggesting that's the one that governed, or are you?
Well, I I think they all do, and let me explain that. Again, my brother would like to make the argument that the 2008-2010 CBA terminated on the end date for that 3-year agreement. But that's not the case with collective bargaining agreements. Collective bargaining agreements by law have the ability to continue the provisions of those agreements, provided they're not modified or otherwise superseded by the terms of a successor agreement. So in practical effect, they never end. They simply continue on. And that's the nature of collective bargaining agreements as provided for by Master General Law, Chapter 150.
Was this one modified by a superseding agreement?
No. And I point that out in my brief. And if you also look at my memorandum in the lower court, which is the supplemental appendix, you will see that the verbiage is word for word exactly the same from the 2008-2010 CBA to the CBA that was in effect when he did retire.
So when Pierce was informed that he could not get the end of year benefit or end of career benefit, whatever it was, what did he do?
Well, first he sent a letter to the superintendent, and he asked what he needed to do in order to receive that benefit. The superintendent several times sent response letters to his inquiries indicating that he was not eligible for it. Nevertheless, Mr. Pierce notified the superintendent in February of 2014 that he was retiring on June 30th of 2014.
So by doing that, was he ignoring the letter informing him that he wasn't eligible?
I think that would be fair to say, because he believed that he was eligible for it. So he pursued that. He did in fact retire on June 30th of 2014, and I sent a letter to the superintendent on his behalf in September of that year, demanding that he be provided with the benefit. The superintendent once again responded that he was not eligible for the benefits, and it's at that time that we commenced litigation.
All right, so so this is, so here's where the judge, I think, sort of strikes a very common sense chord to me. The judge says, all right, if you're claiming under the 2008 to 2010 collective bargaining agreement, when your employment terminated, then you need to grieve under the 2008 to 2010 CBA. And he says, and you didn't grieve under the 2008 to 2010 CBA, so you're out of luck.
Thank you, Judge.
What's wrong with that reasoning?
What's wrong with that reasoning is he classifies Mr. Pierce as an employee.
Well, forget about it. Let's say that he made a mistake, and that actually he doesn't qualify as an employee. Well, no, okay, go ahead. I'm sorry. I should let you finish.
But retirees are covered, right?
Well, retirees were covered by the collective bargaining agreement until the school district filed a petition with the Division of Labor Relations, the Commonwealth Employment Relations Board, issued a decision, which I think is integral to your decision in this case. Because if you review that and you follow their reasoning, which I think is very well founded, there is no way that Mr. Pierce could have accessed the grievance process, because not only by statute, but also by the very terms of the collective bargaining agreement, he was no longer an employee and therefore not entitled to pursue this through the grievance process. In actuality, what I'm doing is agreeing with the superintendent's initial determination when he said, nope, he said, Mr. Pierce is no longer an employee here, and I'm not going to listen to anything regarding him.
The one that was ignored.
Exactly. But they're trying to have it both ways. They want to say,
no, you're both trying to have
somebody
it both
is.
ways.
No,
that one ain't selling to me. You both want it both ways. And the question is, what the heck does this contract mean?
So what this contract means is that the union has the ability to bargain for benefits, provided the district is in agreement with doing that. That's what the SERB decision says, for retirees. The question before you, though, is how do you enforce those provisions? That's the question before you. And the method of enforcing those for somebody in Mr. Pierce's case is that if the district fails to provide him with the benefits, as they initially did with his health benefits, but subsequently relented and agreed to provide him with those benefits. But if they don't provide him with those benefits, then his only recourse is to go to court. There is no grievance procedure available to him. And there also is certainly no claim against the union for failure to represent him.
The reason that there's no grievance procedure available to him is because he waited deliberately until he was no longer an employee and could no longer invoke the grievance procedure.
No, Judge, I would not agree with that. And let me tell you why. Because, first of all, he did deliberately wait to retire because it enhanced his benefit. But if he had terminated on a particular date and then notified the district the next day that the district's position is too late, you have to notify us while you're still employed. But that's not what the collective bargaining agreement says. If you look at the very term.
I lost you there. I'm sorry.
4 months in advance.
Right. And so by its very terms, all the employee is required to do is notify the superintendent 4 months in advance. It
4 months before his retirement.
Right, correct. And I think that just because an employee terminates doesn't mean they retire. I think they're two separate things.
And the reason for that is what? I mean, it seems to me it's got to be based on the language of the contract.
Exactly. And if you look at the language of the contract and give it the plain meaning that it deserves, Mr. Pierce is entitled to these benefits.
Well, but I'm a little confused about what in the contract tells me that he can terminate his employment and then retire 3 years later.
There's
so, you know, this judge, his instinct is you either retire or you terminate your employment, but you don't do a termination and then retire from something you've already terminated 3 years later. That, it seems to me.
I want to ask the same question in a different way, which is if I understood your argument correctly, 12 minutes ago, you were saying that the second CBA did not supersede the earlier one. How do we know that? For superseding to happen, does it have to be explicit? Or in this case, where you had a package of benefits that were included in the earlier CBA that are no longer included in the subsequent CBA, why doesn't that implicitly supersede?
Well, the collective bargaining agreements are attached to the appendix in this case. So I think you can, the language itself is there. But as I stated earlier, the language that provides these benefits does not change at any point in time from the one that was in existence in 2010 to the one that was in existence in 2014 when Mr. Pierce retired.
That doesn't necessarily answer the question, because the question is, does the contract apply to him at the time that a particular action took place? And your position is that
the benefit accrued during
one of these two contracts applies to him at the time he so quote unquote declares his retirement. Is that your position?
Yes, the benefit accrues during his employment. It's by virtue of his employment that the benefit accrues. So therefore, the contract that was in effect at the time of his resignation, the language of which was never changed by the parties at any point in time in the 4 years after that.
So are you saying, if I understand you correctly now, that the subsequent CBA has the exact same set of benefits for retirees?
Exactly, Your Honor. The language
doesn't apply to retirees, but does not apply to retirees, right?
Well, what the SIR board found is that retirees are not bargaining unit members, that they're
They're
not,
not the exact same then.
but they also found that the employer and the employee group have the ability to negotiate and provide for retiree benefits in the collective bargaining agreement. And that's exactly what happened here. Can I just say one other thing? I wanted to rebut a few things that were in my brother's brief.
Counsel, I'm afraid your time has expired. I want to check to see if my colleagues have any further questions.
I do not.
Seeing none, I'm afraid we'll have to go to your briefs for such. We'll now hear from Attorney Pagnini.
Thank you. May it please the court, Attorney Pagnini for the appellees, the school district, and the superintendent, Kevin Lyons. I think it probably makes sense for me to talk a little bit first about some of the facts, because I got, based on the questions from the panel, the sense that there's some confusion as to both the contract in 2008, 2010, the subsequent contracts, and how those all sort of work together. So I'd like to start there. The CBA in question ran from 2008 to 2010. The plaintiff provided his resignation in June of 2010, so just prior to the expiration of that, what I'll call first contract. And to the question as to whether or not that contract has expired, yes, it did on its own terms, explicitly said, and it's in the appendix, at the end of its own term. Now, Chapter 150 is a little bit of a different animal, so to speak, when it comes to contracts, in the sense that it expired because of the parties' agreement to enter into a successor agreement. And yes, some of those terms carry over from one to the other. One thing that I think is important that my brother raised is just prior to, or just a couple of months before the resignation of this individual in question, was when the SERB decision came down, indicating that retirees are not within the scope of that contract, i.e., they're not members or parties to that contract. So, however you want.
Can I stop you there?
And I apologize, I was going to get there.
No.
Moving forward, retirees are no longer part of the CBA.
So doesn't that mean, counsel, that he could not have grieved this?
No, Your Honor, because he could. First of all, he wasn't a retiree at the time that he resigned, right? We've made that point before. Now, there's the question as to whether or not he qualified for the benefits in question at the time that he resigned. And there were some questions about, well, if he was 55, et cetera. And I can and would argue that he didn't qualify for it at that time, which is why he didn't apply for the retirement.
What's
benefit.
hum 3 bars on why that's right? Because what your brother said seems to me to make sense. There could be another way for him to qualify. He says he had 25 years and all he needed was 20. Why is he wrong?
Yeah, because he is no longer an employee or a party to a contract that allows him the benefit that he's seeking. It goes back to justice or
did he, if he had retired in June of 2010, if he'd said, I'm retiring, would he have qualified?
Not as I read the letter of the language under the contract, because he wasn't 55 at the time, right? However, that is the reason why he would have had to have grieved under the first contract if he had a dispute.
That's not an answer to my question. Is your brother wrong that 25 years was enough for him to qualify for some type of retirement benefit at the time that he resigned in June of 2010?
So he wasn't 55, right? And he had to meet all of the items that qualified.
It says and or, doesn't it?
I'm sorry?
Doesn't it say and or?
And in addition to that, and I'm sorry, I'm not ducking your question, it also says that he had to provide 4 months notice, which he certainly didn't do, right? He just resigned in June 2010. He would have had to have said at that time, hey, look.
Hold on. Before we move to that, let's get a
Sure.
direct response to this question.
Yep.
He has to be either 55 or have 20 years of service. Do you agree that those are the options?
Yeah, so I
55
think,
years of age, he didn't have that, but he did come in because he had 20 years of service. Yes or no?
I think it's just a little bit different, and I'll explain. It's the experience factor is in there, and I thought it's 10 years of experience, but I think he qualified in that. Then it says you have to be 55, and then the language reads and/or, what I think you're referring to, regarding the qualifying for the immediate payment of retirement benefits upon termination of employment. Now, of course, that suggests, if not affirmatively states, that the purpose of this language is the notification provision is in there so that the district can provide the benefits immediately upon the cessation of employment or 4 months thereafter, right? That's the whole purpose of the language, is to provide notification to the district so that they can budget for it and provide for it within that calendar year or 4 months after, depending on how it plays out, right? Any reasonable reading of the language is going to be that it lives within that contract for that purpose, right? That you have to provide notification 4 months forward, and he didn't do so. I think there's been some confusion because there's then this discussion regarding whether or not he was an employee, right? And I would put forward to the panel here that the appellant is sort of playing it both ways, and I don't mean to be pejorative, and I apologize if it came off that way. But on the one hand, as Justice DeBeat said, he's trying to have his cake and eat it too, because as was identified earlier, he's effectively saying, I should be getting the benefit of this contract, that first contract from 08 to 010. However, I shouldn't have to do anything that the contract required me to do in order to gain the benefit of that contract. I didn't have to do it at that time, and I don't have to do it now, even though the now is 4 years later. The biggest problem with that argument is that, of course, when he went to go retire formally in 2014, he was no longer a party to the contract, the first contract, 08 to 010, that he's claiming he can now derive a benefit from. They're cited in—
Could he have grieved at that time?
Yes. So I think in order to have at least been able to say, and this is where I think Justice DeBeat correctly went with that argument, that he could now be in front of, for the purposes of this claim, a breach of contract claim, he would have had to have at least tried to grieve. And
Well,
so
that's not an answer to the question.
So
I'm sorry.
So I'm sorry. And then again, I didn't mean to duck, but I just think that's the larger
Yeah, but
point.
trying when your position is that he couldn't grieve because he wasn't an employee gets us nowhere. Is that your position? Your position is he wasn't an employee, so he couldn't grieve. He did not qualify under the language of the grievance clause.
So he could have grieved, but he didn't.
But why would he have? If it was going to be an exercise in futility, why would he expend the resources to do that?
Because he was well aware that that's what he had to do. He was the manager of what was called the PIC.
He had,
committee.
your position is he had to go through the process of going through a futile gesture in order to then have the right to sue in court?
It would not have necessarily been a futile gesture. Part of the grievance process is, and this is laid out in the briefing, that he would have, and this was a point of discussion at the motion to dismiss phase, that in addition to the grievance argument as to the 08-010 contract, he had to have turned around and said the union didn't represent him fairly, and have had to have exhausted that grievance as well, that claim as well. And he didn't do that.
But at that point, he wasn't a member of the union, correct?
He is taking that position now, yes. So Justice DeBeat focused on the failure to exhaust
taking that position in part because there was a decision by the governing agency that the union didn't represent retirees.
I mean, that applies to, so first of all, I think it's in the appellant's brief that he wasn't even aware that of the CERB decision as of the time that he could have or could have not.
I'm not sure that that matters.
In any event, he always could have grieved. He didn't grieve the nature of his resignation, i.e. the circumstances that led to that. And again, he very well could have. And if there was a question as to the retirement and whether or not the
But
retirement
when you say
language,
he could have grieved,
yes.
I just want to nail, I want to try to nail this down,
Yes.
counsel.
So what I mean is,
When you say he could have grieved, it is your position that his grievance would have had to be denied because he was not an employee and therefore did not qualify under the language of the CBA, yes or no?
no. He could
Why?
have grieved. He could have grieved during the life of the first contract.
Okay.
08 to 010, right? He was an
Yes.
employee at that time, or at the time that he was resigning, he could have grieved. Move forward 4 years, he's no longer a party to that contract. So he can't say, it was not possible for him to have grieved at that point, I suppose, because it's 4 years later, he's no longer a part of the contract. But that goes to, he's no longer able to get the benefit of that contract because he's not a party to it and it's expired. So this is where the plaintiff has pointed to this O'Neill case, right? Where there's a superintendent who said, look.
So that seems to me that one of the key components of that argument, let me just try to reframe it.
Sure.
It is, he no longer had rights to retire in 2014. And you gave two reasons, the first of which is the contract has expired. And how do we know the contract has expired? That language we're going to find in the 2008 to 2010 CBA?
Correct, Your Honor. Yes.
Okay, but I heard you say earlier that parts of that agreement live on pursuant to Chapter 150.
And I hope I didn't suggest something to create a contractual right in the sense that the agreement lives on. All I meant to say was that there are parts of an agreement, a CBA, that are then in the subsequent agreement. But the 08-010 agreement, upon its own terms, ends when the successor agreement begins.
Does the successor agreement, does the agreement actually say that? Is there something?
Yes, it's in the agreement. Yes, it's in the agreement. But I think the
Distinguish O'Neill. Distinguish O'Neill. You were about to distinguish O'Neill. I want to hear you.
Yeah, sure. Thank you. In O'Neill, there's a superintendent, and the claim was that it's akin to this case because he was looking for benefits that derive from a contract after the contract expired, and that's not the case. The point there, I think, is one, the superintendent, and I would be mindful that it's a superintendent, not a member of a CBA. That's one distinction, but I don't think it's the most important one. He gave proper notice under the agreement and timely notice under the agreement, i.e., he was able rightfully to argue, because I gave notice under this agreement, I should be able to derive a benefit of the agreement as it states, different from here where the agreement had expired and the claimant is saying, I want to go back to that expired agreement and trigger something 4 years later, even though I'm no longer an employee and the CBA has expired. The other notable distinction with that case is the agreement in question was the payment of health insurance benefits indefinitely towards the superintendent in question. And the question there was whether or not that violates another statute as to whether or not it can go beyond 6 years. But the takeaway point I would suggest is that the benefit in question was triggered and arose while the claimant provided timely notice, which is completely different from here, which is after the fact when they're no longer an employee. There's two other arguments that the lower court didn't reach that I would suggest are also dispositive of the case, in addition to the exhaustion argument. One is that it was and I think I touched on this, but I just want to make sure that I'm putting this before the panel, that the CBA in question, 08 to 010, expired as of the time that the request was made. And I think that my brother said that the superintendent at the time, basically said, no, you're no longer an employee. But if you look at the record, he didn't say that. It was really, I think, because, and I don't know that he gave a reason, but the contract at the time was expired. So we couldn't go back and get that benefit in that expired contract. The discussion about the retiree, I think, is applicable because as of the time he retired, it also, the new agreement, which actually is 2 agreements later, 08 to 010, 10 to 13, 13 to 16, you were retired in 13 or 14, didn't cover retirees. So he didn't have an argument that, wait a minute, I should be able to access this version of the contract as a retiree. He couldn't do that, which is why he's going back and trying to argue that he should be
How
able
do
to
we
get-
know that the 2013 CBA didn't quote unquote cover retirees?
That's the CERB decision, Your Honor. That was mentioned.
Well, shouldn't we have to look at the contract first rather than take the word of some authority that may or may not be right?
I would submit that CERB, which is the binding authority as to labor issues, is certainly binding as to that agreement.
You know, I think we have to look at the agreement. Well,
And there is the
hence
agreement
my
there.
question, how do we know in the agreement?
Yeah,
We'll have to figure it out. Okay.
Yeah.
Okay, do either of my colleagues have any questions?
Interesting case.
Extremely interesting case, well argued on both sides, and the case is now submitted. Thank you both very much.
Thank you.
Counsel, there's no opportunity for rebuttal.
You're on
And
mute anyhow.
You're on mute anyhow.
Pardon me, I wasn't going to argue. I was going to request leave to further supplement by filing 2 additional documents that were filed in the lower case, namely the defendant's memorandum in support of
Okay.
summary judgment.
Counsel, we, to the extent that you feel the need to file a post-argument motion, you can certainly try that. That is certainly not a promise by this panel to entertain or allow that, but you'll have to do that in writing.
I appreciate that.
Yes,
Thank you, Your Honor. Thank you
Thank you
very much.
all very much. The case is submitted.
All right, we are now live and recording.
Thank you all very much. We are back online for our last case of the day. It is 2020 P 921. It is a DCF care and custody matter. We will refer to the parties by their status. And I just want to remind folks that we have read the briefs, or we are familiar with both the underlying facts and the arguments. So I would urge all counsel to cut to the chase to the extent possible. And we will hear first from the attorney for the mother, Attorney Foster.
Good afternoon, Your Honors. May it please the court, I am Attorney Catherine Foster on behalf of the mother in this case. And this case is about a mother who struggled, but who also displayed significant strengths. She was imperfect, but not unfit. She struggled with medication management. She was disorganized and missed some visits. But when her son was at home with her and during visits, she parented him well and he responded well. Unfitness must have a prognostic, but not a preemptive dimension. While the court doesn't have to wait for a disaster, the court's role is not to terminate just in case. This court has said good intentions and genuine concern are not a substitute for clear and convincing evidence of current parental unfitness. In the court's initial order terminating mother's parental rights, the court found that nothing had materially changed since the parent stipulated to unfitness in August 2018. In a way, the court was right. Mother was in the same apartment. Mother was still in therapy. Mother was still in medication management, and she was still visiting her son.
Was she still abusing substances?
Her sobriety at the time of trial looked like it had improved. She had weaned herself from methadone. She was undergoing random drug screens, and there was no information from any of her providers or of any hospitalization or police response due to her overdosing or being hospitalized for drug use.
Was she allowing them to count her pills?
After they removed the child in July 2018, she stopped letting the department count her pills.
So that was a change, right? Or no?
It was after she had custody of her child until July 3rd, and then after his removal, at the time of the temporary custody hearing is when the parents both stipulated to unfitness on August 10th. So the court was going from August 10th until the time of trial, and that actually was consistent throughout. So that wasn't a change. But the court abused its discretion by terminating mother's rights on that basis when nothing had changed from the time it refused to allow DCF to dismiss mother's case because the child was doing well despite mother's imperfections. And then again, when it allowed DCF to remove the child who was doing well in his mother's care when nothing had changed except for the positive drug screen.
There were 11 positive fentanyl screens between 2017, when the child was first removed, and the time of trial. How many of those screens occurred between the time that the child was removed in 2018 and the time of trial?
I don't have that precise number before me. I can get it to you.
Is there some place in the record where we can see the list of positive fentanyl screens?
I'm not sure right at this moment, but I can submit
Okay,
that.
that's all right. We'll figure it out. Thank you.
Okay, I'm sorry about that.
Were the children home at the time that the house was raided and they recovered 17 grams of heroin?
Yes, they were. That was in 2015, and the father was arrested at that time. The mother broke up with the father at that time and pursued housing on her own with the children, which is where she was in 2017 when her neighbor became so abusive that she had to send the kids to their grandparents, and she herself became homeless. Which is how she found herself in the U-Haul office seeking paperwork to provide to housing authorities. But she was sleeping in her car and exhausted. The grandparents were watching the children, but she did have the children with her at the time. And she was able by August to get new housing, and she's had stable housing throughout the proceeding, which arguably is a large part of the reason why the case opened in the first place, because she, was homeless at the time.
Does she work?
She has worked. There is record of her working in several places in the record. The purpose of a care and protection proceeding is to protect the children and not to punish the parents, because when the state punishes the parents, it's the children who suffer. And here in particular, the contrast is really clear. A few days before his removal, the child was sitting on the floor of his living room, playing with trucks and smiling at the social worker in the comfort of his mother's home. After his removal, he was so distraught that this 5-year-old boy began to self-harm by biting, pinching, and scratching his own body.
Can we just go back to that last question for a moment?
Sure.
Because I didn't really see this issue addressed at all in the briefs. What is the evidence of record as to how the mother supports herself, has a stable home after the father is incarcerated? So she has to support herself, have a stable home, and take care of an infant. And what's the evidence in the record as to how she's accomplishing that?
Well, I'm not actually clear on that, Your Honor, because it wasn't a concern that DCF had at the time. So what didn't really become part of the case. I can look for that in the record, but
I think that's quite uncommon in cases like this that we see. Usually we have some sense of how the mother is going to both take care of the child and support the child. Okay, I agree with you. I couldn't find it in the record. It wasn't addressed in the briefs.
Yeah.
Was the mother taking her medications at the time of termination?
Yeah, she's been taking the same medication since she was about a teenager. I
thought there was some either argument or evidence that she wasn't testing for the medication she was supposed to be taking.
She did struggle with her med management. She struggled throughout. She struggled when she had custody and after the child was removed, which is why mother is arguing that that particular struggle did not actually make her unfit. She struggled with her medication management during the 9 months that she was parenting her child, and her child was doing really well. The department wanted to dismiss the case twice because the child was doing well. And even though mom had struggles, the child was doing well. So just in closing, Your Honor, mother's loves her son. She parented adequately despite her imperfections. She's grateful that the department didn't recruit strangers, but reunited her son with family in the form of her mother. And mother asked the court to take one step further and to make this family whole again by vacating the judgment, terminating mother's parental rights, and remanding to the trial court. Thank you very much.
Do
Yes.
either of my colleagues have any follow-up questions?
No, thank you.
No, thank you very much. We'll hear from the father's attorney, Attorney Penta.
Good afternoon, Your Honors. I'm Michael Penter, and I represent the appellate father. This court has settled in its holding, a holding codified by the legislature, that a parent cannot lose their rights to their child simply because they happen to be incarcerated at the time of the care and protection trial occurred. This court has also settled long ago that when assessing competing plans, the judge is not to give preferential treatment to DCF plan, and certainly cannot simply defer to DCS plan. Otherwise, an even-handed assessment of the competing plans is nothing more than an illusion.
Do you challenge what's being done now?
I don't know enough information to dispute that what is being done is in the child's best interest. Certainly being with family is better than the original plan that the department submitted. But what is lacking from this is, and this is only the record that was provided by child, is what is the plan? Is it guardianship? Is it adoption? Is it something that requires the termination of a parent's rights? My client has a wonderful relationship with the maternal side of the family, but simply that he's placed with the mother, it hasn't shed enough light on this. And I think that's the reason why his determination decree should be vacated, because he would then have an opportunity to participate at the trial level with this new plan, which might be something that he would be in agreement with or might not be, but there's simply, when his rights are terminated, he doesn't have any ability to know what's going on or participate and have any standing.
Counsel, is it fair to say this is a new plan, or is this a refinement of the existing plan? Because the department was looking at family placements, if I'm recalling the record correctly.
You're correct. They were examining, and in their plan, the written plan, they actually, maternal grandmother at that time, although they were considering her, had not responded to their letters or returned their calls. And my client's the record at page 285, the third page of the department's plan. So although they were exploring maternal grandmother at the time of trial, that was a plan that hasn't even been whether she would agree to it, just simply because there was a number of things that were going on. One, she wasn't responsive to the department at the time. Not to say that she wasn't quickly thereafter, I don't know. Once the trial ended, my client isn't privy to that information. But after that has occurred, she was out of state, so there was still also another hurdle to overcome with the IPCPC. But it's not just that the department's plan, Your Honor, I just want to make it clear, is that my client's plan was simply dismissed because the department felt it wasn't in the child's best interest at the time they examined both the kinship placement application and the adoption application. In fact, they didn't even consider the adoption application. Dr. Resource, a social worker, deferred to the prior denial of the petition. And the judges does not make any assessment independent with specific and detailed finding why this plan was not in the child's best interest, or why it shouldn't have been considered for this child, because the department had rejected. And that
what was the father's plan beyond, upon his release in 2022, he was going to go to a halfway house?
Well, my client wasn't looking for custody. My client was in prison. He was looking for his mother to become the child's custodian while he was during his compelled absence due to incarceration. So this was really a competing plan as it relates to my client. But his plan doesn't necessarily, a finding of unfitness, even if he's temporarily unavailable, doesn't require a termination. It's actually contrary to the policy of the Commonwealth to keep families together unless a termination decree is absolutely necessary for the child's well-being. And that's not necessarily clear from this record because the judge dismissed out of hand my client's plan that didn't require such an extreme measure. And those words aren't mine. Those extreme measures are come from the appellate courts.
What was the father's plan again? I'm sorry.
His mother, the paternal grandmother who had a relationship with this child, who from time to time was a caretaker for this child, to continue to be a caretaker for this child, at least until his release and probably thereafter. So, and the courts do say that if the plans are incomplete, or if the judge finds that and this wasn't the case here, the judge didn't dismiss it because there was missing information, she dismissed it because the department dismissed it. But to answer a hypothetical or to answer a question that if the judge or this court finds that the record was incomplete as to what that plan was, the proper course is for the judge to suspend the proceedings and invite more information. For example, asking the probation department to do a home study to get that information. So if something's in the child's best interest, it shouldn't be dismissed simply because the one of the presenters of the plan had not provided evidence that the judge may have thought sufficient. I did say in my brief that it probably would have been a better practice if the paternal grandmother had testified, but that doesn't mean the judge should be taking actions that could be contrary to the child's best interest, especially when the plan presented by the department, I submit, is wholly incomplete. And that's why this case is somewhat different than Varick, which is a case recently where it's kind of deviated from the norm about the finding that a parent's rights shouldn't be terminated if the plan for the child, without an assessment of the child's plan. In Varick, there was no other competing plan. It was the father in that case did not present the plan. It was a one plan show from the department. So in that case, the father was unfit. He was repentantly unfit. He thought that physical abuse of his child was the only way to keep his child in line, but most importantly, he didn't submit a plan. So Varick is a distinction because it's not a competing plan case. It's whether the department's plan was sufficient to warrant its approval. And the court determined it was not. And I submit to this court that this plan mirrors that very much so, to the point that the judge went painstakingly to a Rule 126.
There's a difference. I mean, we have cases that distinguish Varick because the child in that case had particular specialized issues that required particular specialized attention. And in this case, by the time of trial, that was not evident with respect to this child. Am I wrong about that?
I don't know if you're wrong, Your Honor, because I believe that the judge makes some incomplete findings on that in her conclusions. I don't, in my brief in here, if you indulge me, there were some income, I don't have it right at my fingertips, but there was some notion in the judge's findings that the child had special needs and that he didn't have special needs. So it's not quite clear.
Well, the child had issues early on, but what I read was that by the time of trial, he had stabilized with the foster home. And I could be wrong, and I'll take a look at that. Let me ask you a completely different question.
Sure.
Was the father part of the stipulation of dismissal of the case that was a joint stipulation that was rejected by the court?
My understanding is he was.
And this is the question I should have asked the mother, but is there a claim that was error that could be remedied now?
Is there a claim that was error that could be remedied now? I certainly believe that this court can, on the totality, vacate the termination decree as to both parents, reinstating their rights to participate in further hearings in this case and address it at the lower court. I would, again, probably a question that would have been best for mother to answer because it wasn't the focus of my advocacy for my client. But I certainly think that this case does scream that there is a number of errors that warrant remanding it to the court, if nothing else, for further consideration of not only my client's plan, but the department's new plan that, while it meets some of the itinerary that they set forth in their at trial, it is completely undeveloped as far as I can tell what that plan is for the client, for the child, excuse me. And again, I think it would be beneficial for all the parties involved to have this remanded back to the trial court in order to have that issue addressed, specifically where my client's plan was dismissed in violation of long settled principle of law.
Do either of my colleagues have any further questions?
Not for this council, but I'd like to know what the child's position is prior to hearing from the department, if that's possible.
Person I agree with, I'm sorry.
Thank you, Honor. I'll say that I represent the child, Rizwan Hulafa child, and his position has evolved throughout this case. Excuse me. As of now, the child has been living with his maternal grandmother in Florida since March 4th, 2021. He's grown accustomed there. He likes it there. He's basically the first place that's provided him some stability in a long time. He also likes the fact that he's had access to both his mother and father quite frequently by phone. So that is the reason why I struck my brief. He does like being with his maternal grandmother. The only
counsel from the child's perspective, is this an adoption scenario, a guardianship scenario, or something more informal?
I would think the issue is really guardianship versus adoption. The issue that with guardianship, with the issue with adoption, which is DCF's current plan, is that the mother and father would have no standing if something happened to the maternal grandmother. That's an issue for the child. I think from child's perspective, that is the issue moving forward. There's no
Child
question.
has been with maternal grandmother how long? About
It's
8
March
weeks?
4th. March 4th. Yeah.
No,
So almost 3 months.
Okay.
Yeah.
Any further questions for child's counsel?
No, thank you.
If I may just say and answer Justice Engler's question about the positive test for mom, you can find that in the findings of fact from 183 to 203 on the record appendix 78 to 80.
Thank you.
Thank you very much. We will now hear from the agency.
Good morning, Your Honors, or afternoon. My name is Jim Peterson, and I represent the Department of Children and Families in this case. I just would like to address Justice Englander's last question about the motion for dismissal first. That is a case I don't believe that you can solve this now, that this is not the time. It's not right for it to go back. The time it was right to appeal, to challenge the court's finding at that time, the lack of dismissal was back in 2018. That was when it was. That's not what happened. And in fact, just a few months later, very shortly after, a month later, the child was removed a second time.
So that's fascinating, counsel, and that is exactly what's on my mind. So let's ask the question in two parts. And I'm number one, because I've never seen it before. Does a judge have the authority to reject a stipulation of dismissal filed by all parties?
Yes, in this case, because although it's required under the civil rules of procedure, the civil rules of procedure do not apply to these cases. That's explicit. It does give guidance, and a lot of judges will apply it, and a judge isn't going to be flipped.
So that's a partial answer to my question, but it's not an answer to my question. Okay, so the civil rules don't apply. What authority does the judge essentially have where none of the parties want him to be involved?
But at this point, there's nothing that says there's nothing that says anything either way, quite frankly.
Well,
There's
yeah,
nothing
there is historically, at least, there's the whole concept of a case or controversy, which comes from the federal constitution. I mean, as an ordinary rule, a judge doesn't have in rem jurisdiction over a party. And that's essentially what happened here. The judge took in rem jurisdiction over the child and said, I don't care if none of the parties want to be in front of me. I'm going to force this case to continue. Is there any case in Massachusetts that suggests that that's appropriate?
There's nothing on point that any party here, and I looked for them.
Let's assume that was improper. The judges don't have in rem jurisdiction over a case that none of the parties want them to have jurisdiction over. What you say should have been done, because what you're saying is nothing can be done about it now because the case continued and the judge had a trial and he found some facts that are adverse to certain parties. But why is that?
And I just want to address that part briefly. This is very similar to a criminal situation where there's a probable cause, a challenge to probable cause. You can challenge probable cause, but once you get all the way through a trial, this court will not review the probable cause determination in a case like that. So whether there was or not, the time to deal with that and to appeal that is at the time you're, as a defendant, alleging there's not probable cause.
Counsel, following up on your criminal analogy, why isn't this similar to, in a criminal case, the prosecutor and the defendant agreeing to a null pros and the judge saying, no, I don't think so, we're going to have the case go forward, thus usurping the role of the prosecutor?
Can't cite the exact rule of statute or case law. However, a null pros is solely with our Article 30. A null pros doesn't require anybody else's agreement. That is in the sole discretion of a prosecutor. If the judge disagrees when a prosecutor files a null pros, and in fact, even if the defendant for some reason disagrees, wants to have his day in court, that is the sole authority of the prosecutor to file a null pros.
Really a question of who has jurisdiction over the child, DCF and the executive branch, or the judge and the judicial branch.
And I don't know the answer to that question. And I was hoping there would have been a case on point that would have been able to really help with that.
Gives me heart that you have checked.
So was it the judge's position that it wasn't in the best interest of the child to dismiss?
At this point, no. And in fact, given the information that was later determined, how mother was attempting right there, right before all that, to hide her recent positive screens, her continuing ongoing use, the fact that she had used and somebody had overdosed in her apartment, all of this unknown at the time. The overdose was known, but not that mother was using at the same time. Not that she had tried to hide the other positives, had tried to squash the subpoena to get that her lawyer had apparently filed to get that information into court.
Okay, slow down for a moment because this actually, and so one question would be DCF's position on this has changed. At one point, DCF was ready to dismiss. It no longer believes dismissal is appropriate, obviously. And are you arguing to us that we would be able to determine from the record that at the time that DCF was prepared to dismiss, there were facts that were being withheld from DCF?
Yes. I think that's absolutely fair. And the two that I just...
How could we determine that from the record?
They're in the record. In fact, some of it was in the... one of them I think I cited in the brief. The first one I referenced, the overdose, it was known that mother in March of that year that had called 911 and somebody had overdosed. She didn't report that, and DCF knew that as well. What they did not know for a year later is that until she told the social worker testified, right? And that's it. So that's in the record that she was the one who was using as well. The other one, again, it is in the record. I believe it's in my brief that there was mother had also, and this came from the records from her treatment center that weren't subpoenaed in until it was getting closer to trial. And in that one, it actually explains that she tested positive. This would have been in, I can't recall, before the June 1st date. She tested positive and she said, no, I want to test, or I want that off of my record. And in the record appendix, in the exhibits that were at the trial, they said, no, I mean, we don't take them out. And this is all going to the court because it's being subpoenaed. This is not a direct quote. But she then called her attorney in front of the director of the treatment center and demanded that the attorney pull that subpoena and make sure that those did not go into the court. She did something again when she also testified.
Was that information that was not known to DCF at the time that they were stipulating the dismissal and came to light afterwards? Is that what you're saying?
That's my understanding. That's the way I have read the record entirely. As you can tell, I didn't brief on this, so I can't really point and say some specific thing. But yes, the way I've read the record is that those records did not come in until later. That information was not known because it wasn't in anything until those records were subpoenaed into the court to look at. And that was not, those two incidences, well, the second one in particular, was not known at the time. That's my reading of the record.
I hear what you're saying. Okay, I maybe this was too much of a side, but it really strikes me. The mother's raising the issue to some degree. They're saying this was improper for the judge not to dismiss the case when there was an agreement to dismiss the case. And it seems to me there are multiple potential responses to that, but I wanted to make sure I understood that one.
And that is the rest of the department's response is that I understand your concern. It doesn't go directly to your concern, but is that they don't follow the rules, that she didn't have to apply it. They never, also the reason, what it really was you're going to trial or you're dismissing this. On June 1st, you're going to trial or you're dismissing it. And the DCF at that point, the prosecutor, the attorney for DCF didn't think there was enough apparently and filed a stipulation, but the judge didn't just deny it. So we're not getting to trial. So the predicate for all of this was go to trial or it's gone. And because they didn't think you could go to trial, but when the trial never came up, when the docket was jammed up with other things, the judge said, well, I'm not getting to it. I'm not accepting it.
Can I change the subject for a moment?
Yes, you most certainly may.
Unless my brothers have different questions. Articulate for me the evidence in the record that indicates and I don't want 400 findings of fact. That's not going to help. But what evidence is the critical evidence that shows that the mother did a poor job of parenting her child? What is the evidence that indicates that, and that she would that was likely to continue indefinitely?
The strongest evidence was her unwillingness, of course, to stop the drugs and use them around the child. As recently as February of the month before trial, when she appeared at and I want to be clear, there was no drug test on that, but she appeared in front of the social worker who knew mother, who knew her behavior, and who was trained to detect drug use. She'd noticed this in mother at other times, and she described mother's behavior at a parent-child visit that was significant enough: pale, face swollen, pupils dilated, didn't move or draw when speaking. It was difficult to speak at that time.
February 2020?
Was that social worker
Green?
Miss Green was a social worker?
Boy, I can't recall which one it was off the top of my head, but I know it was the one who had she's also the one who had asked mother just a few months prior at one on November 12th of 2019, when again, she appeared to be under the influence of something. Her speech patterns were different, pupils constricted. And she said, I want you to get a drug test. Mother agreed. Mother didn't follow through. So it's this recent, ongoing, continuing behavior and her willingness to show up in those conditions, even in front of, not only with the child, but right there in the DCF, with DCF present and with the child. That's what presents the real danger, that she has not moved away from all of her years of substance abuse. When were the most recent positive fentanyl screens to trial? Do you know that? No, I don't. I was trying to find the dates after you asked it, and I don't have a list out as well. The judge, I can tell you, the judge did in the findings go over quite a few of them, and unfortunately, I didn't write the numbers down that the attorney who had mentioned. But she does discuss a lot of those, and they are in the appendix in the records that came in from her treatment center when they were doing it. But I will say, it wouldn't have been after December of 2019 because she didn't get any drug tests, or she didn't give any information to DCF or the court about any tests after that date, even though she was supposed to, and that was part of her action plan. This is after she had terminated. She was getting the tests done when she was at her, when she was getting her treatment, her methadone, but she, again, against advice, decided to get off that on her own and get away from there. She had also her doctor, who I don't think was doing any of the tests, but he had also gotten her out of the practice, dismissed her as a patient. And at this point, she wasn't getting them and was not providing them. The judge did make that finding that she wasn't providing them. So you're not going to find them, certainly in 2020, simply because there was no information, which again is consistent with a lot of what Mother did, where she would agree to do something and then not do it, or she would just simply not provide this sort of information like this when we wanted. And this is the several times. And these are all reasonable requests. These aren't unreasonable requests to say, you look like you're under the influence. We want to make sure you're not. Please get a drug test and have her agree. And then she doesn't follow through and do that. That was even something her therapist had recommended she do something. Oh, it wasn't that. I think it was the medicine, all of her medication, to get a medical evaluation, see whether she's should be taking all those, why she's taking that. Again, she agrees, but she wouldn't do those particular tests. And those are really the consistent things. That's the really, so again, it's that current apparent use that's been going on, her unwillingness or inability to take her medications that she has as prescribed, which ultimately got the doctor to dismiss her from his practice. Her unwillingness to comply with the action plan and to do these tasks, and her chronic absenteeism from the parent-child visits, which had been happening the year before. She had missed nearly half of the visits, and the year before that, approximately half as well. And even despite DCF trying very hard to keep them on the same day, make it easier for her to visit.
Which years were that? 2018, 2019? Nearly
Correct.
half the visits?
Yeah.
Okay. Thank you.
You're welcome. I see my time is expired.
Yeah, do either of my colleagues have any further questions?
No, thank you.
Thank you all very much. I want to thank you not only for your hard and able work on this case, but also the sensitivity to which you, all four of you, brought to these difficult issues. The case is now submitted, and that concludes our hearing today. I want to thank Tatiana Tway from our clerk's office for all her able assistance in this Zoom hearing, which for me, since I'm sitting live next month, it will be my last Zoom hearing.